Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. I have my partner in crime sitting next to me. So thank you for joining us as we continue our coverage of Florida versus Radford, also known as the dog park murder trial. Aaron says I look like a tomato in this, and in actuality, it's kind of a coral salmon color. So I'm kind of interested to see on my screen, I look like a tomato. What do you guys think? Do I look like a tomato, or is it more salmon and coral to you guys? Tell me what you think. In the meantime, let's see who's here with us. Therapist you know, first in chat, Brat, good morning to you. Baka, Little Miss, good morning to you. Lily Wayne, good to see you. Thank you for joining us, Brenda. Grass is green enough, good morning to you. Ken Rosenberg, if lawyer objects in an empty courtroom, does it make a sound? Nice. Great question. 99% of people polled say yes. Good question, Ken. Hey, only fan. Shirley Roth, hello to you. Capri Law, good morning. How was your opening day? Hey, Alice Howell. Hope I'm pronouncing your last name correctly. Thank you for joining us. Did I see Curviel? Curviel, were you in here? Did I miss you? I thought I saw you. Maybe not. All right, Curviel, if you're here, hello. If not, Reddish Coral, Irish Amy, hello to you. We'll give another shot of Super Ball sleeping peacefully in her little cat bed. So on the screen, I look like a tomato, but in reality, it's more salmon corally. Super Ball sleeping. Yes, she's all chill. It's a beautiful Friday. You'll go with coral. Looks great. You love that color? Good. Yeah, I can't tell because I'm using a TV screen versus a computer screen, so I look like a tomato. Aaron says. Oh, I said it correctly. Awesome. Thank you, Alice. Hey, Super Ball, furry greetings. Salmon for you. All right, cool. Thank you. Thank you. Carol O'Neill, thank you. Good to see you. All right, so we're going to continue on with day 3. Now, the state rested, so the state had 2 days to present their argument. And we heard a lot of testimony yesterday from the dog park crew. And for those that are not familiar with this trial, the event happened February of 2024, and the trial actually was February of 2025. So it literally was like a year afterwards. Let me just get to my notes here. So the defendant is Gerald Declan, or Deck as they say, Radford. And here, let me go to here. We'll do a little recap here. Let's see. We can get rid of, not that one, Chris. That one? Nope. Which one is it? There, that one. All right, so John Walterley, you hear a lot about Walter. So that's the gentleman who he was shot. So Declan Radford, he's pretty much, by all accounts and his own words, he's an ass. Basically, he admits it. He says it. So I'm not disparaging him at all. So they're in this dog park. There's this group, people that walk their dogs. They hang out under this pavilion. COVID happens. People become polarized along, party lines. And Radford is very one side of the eagle, if you will, one side of the bird, and John Walterley is the other side of the bird. Same bird, 2 different wings, John comes out. He says he's gay, says he's happy and proud about it, and generally the dog park crew is cool with that. Everybody's like, all right, cool, good for you. Even Radford said congratulations, and he was okay with that. But he also admits that he's very harsh, abrasive. He's from Jersey, where he grew up. Not that makes people harsh and abrasive, but where he grew up, he says that's just his way of talking and acting, and he would make very really nasty comments towards John once he came out. So eventually it comes to a head where they're at the park alone. They get there in the mornings usually, and we don't know John's version of it, but Dec's version of it is that John came at him, hit him with his mug, and they knocked him down. Dec had a gun, pulls the gun out, and goes into Walt's top right chest, almost at, like this kind of angle, goes down through his heart, through his lungs, ends up at his back, through his diaphragm, basically just kind of rips through his entire body, right side of his body. And he's pretty much dead within probably 10 seconds, of that. So that's where we are with that. Dec Radford, he's being charged with second degree and also hate crime because of the nature of Mr. Lay's proclivities, if you will. So, who has come in? Hey, Jim, good to see you. Thank you for joining us. Appreciate it. Fala, gimpy hugs. Aw, Fala, here's virtual hugs for you. Virtual hugs for Fala. Forrest Nelson, hey, good to see you. Thank you for joining us. Appreciate it. Irish Amy, good to see you. Hey, Paul, does Chris look like a tomato? What does it say? It's a no for me, dog. I don't look like a tomato. Good. Let's see, who else is with us? Evil Queen, good morning to you. Traveling Teresa, good morning, good morning. Thank you for joining us. All right. Yeah, Jim, thanks for joining us. Always good to see new faces in the crowd. All right, let's get to it. Yeah, Capri, did Fala hear what Walt's dog name was? Yes. Fala, I believe she did hear. All right. Oh, Evil Queen, thank you. I can share it on all my platforms. Appreciate that. Thank you so much for that. Appreciate the support. All right, let's get to it. This is day 3. This is going to be the defense. This is the defense case in chief, day 3.
FDLE lab analyst Maureen Meehn.
All right.
Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but?
Yes, I do.
Thank you, ma'am.
Please start this way.
Hi, good morning. If you would please introduce yourself and spell your name for us.
My name is Maureen Meehn. First name is spelled M-A-U-R-E-E-N. Last name M-E-E-H-A-N.
Good morning. How are you today?
I'm good. How are you?
I'm good, thank you. Could you tell the jury how you are employed?
Yes. So I'm employed at the Florida Department of Law Enforcement as a crime laboratory analyst in the biology section.
Could you please describe for the jury what you do as a crime laboratory analyst in the biology section for the Florida Department of Law Enforcement?
So I examine items of evidence, testing for possible body fluids such as blood, semen, and saliva. I will collect samples from this evidence, develop DNA profiles, make comparisons to known reference standards, calculate statistics, and release a report.
Were you tasked in this case with analyzing a series of, I believe it was 7 items for potential biological material?
Yes.
Permission, Judge, by stipulation, I've got pre-marked what would become defense exhibits 4 through 10. The defense would move by stipulation with the state to have these admitted into evidence.
All right, will be received.
Just briefly, permission to approach the witness, Judge?
Yes.
We don't have to go in. Then I just have a couple of questions about it.
Yeah.
Okay.
And for the record, Judge, I have the witness take a look at what has been entered into evidence as defense exhibits 4 through 10. Ms. Meehn, do you recognize those exhibits?
Yes, I do.
Are those the items that you were tasked with analyzing as part of your involvement in this case?
Yes, correct.
I specifically want to focus on, and just, I guess, to fill the jury in on how this process works. When you receive items, they come to you without that FDLE tape on them, right?
Yes, correct.
You open them, you process them, and then ultimately, once you've completed your analysis, they get sent back to the respective agency?
Correct.
In this case, I want to focus on item 1 that you analyzed. Do you recall what that was associated with?
Yes.
And could you tell the jury what item 1 was associated with?
Swabs from the sights and slide of the pistol.
Now, prior to your analysis of this particular item, did you receive known standards from specific individuals?
Yes, I did.
And who would that be in this case?
I received a bloodstain card from John Walter Lay II and buccal swabs from Gerald Declan Radford.
Did you utilize those samples to attempt to make comparisons to the items that you were sent?
Yes.
As it pertains to item 1, what were your findings?
So this item demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male individual.
Were you able to determine whether or not Mr. Radford's DNA was present on within item 1, the swab from the sights and slide of the pistol?
So I was able to include Mr. Radford as a possible contributor to this mixture.
As it pertains to Mr. Lay, what were your findings?
Comparison of Mr. Lay to this profile, I was unable to provide either an inclusion or an exclusion, so no determination was made.
One moment to confer, Judge.
Sure.
And for clarity, Ms. Meehn, if I understand correctly, if you could explain to the jury, there was a mixture of DNA present on the sight and slide swab.
Yes, correct.
Which indicates to you that it would have come from 2 different contributors, right?
Yes, that's what I determined.
And you couldn't include or exclude Mr. Lay as a contributor to that sample?
Correct.
I have no further questions, Judge.
Morning, man.
Good morning.
You actually looked at a whole bunch of things, right? There's actually a series of, where do we go? What happened? You actually looked at a whole series of swabs, right?
Yes.
I think, not counting bloodstain card and buccal swab, you looked at 1, 2, 3, 4, 5 different swabs attributed to firearms or other items. Is that correct?
Yes.
And just so the jury understands, so they don't go back and have to debate amongst themselves what these things are, What's a bloodstain card, and what do you do with that?
So bloodstain card is a reference standard, so the origin of this DNA profile is known. This is typically evidence that's collected at the medical examiner's office. The blood is collected and dried onto a filter paper.
And then you can eventually somehow get DNA out of that sample of blood dried under the paper, and that's how you get the DNA of a person. In this case, the victim, Mr. Lay.
Correct.
What's a buccal swab?
So a buccal swab is another example of a reference standard. Again, the origin is known. These are typically swabs taken from the inside of an individual's cheek.
And then you can use that to get the DNA profile of, in this case, the defendant, Mr. Radford.
Correct.
And at that point, we have like known profiles attributable to specific people.
Yes.
And for the record, so the jury understands, Exhibit 9 and Exhibit 10. 9 is the buccal swab of the defendant, and 10 is the bloodstain card of the victim. These are the things you use to first have a working knowledge of what DNA might be attributable to any specific person.
Yes.
Now you get 5 other samples. That's 8, 7, 6, 5, and 4. I'm running backwards, sorry. And those are swabs from items.
Correct.
And 3 of those swabs are swabs from different portions of the gun. Are you familiar with a firearm enough to at least help me explain the different portions of the gun?
Yes, I think so.
Okay, so there it is on the TV. This portion up here, and these little things that poke up off the top, what portion of the gun is that?
The slide.
The slide, and these things at the top, are these the sights, basically?
Not familiar with that, but yes.
Like if I was looking down the gun, I would use that to aim?
Yes.
Okay. Then there's another, the lower portion. What do we call this section?
So that contains the grip, the trigger as well.
Yeah, the grip, the handle, the trigger, all these sorts of areas. And then if I turn the gun like this, and I'm looking at this hole in the front of the gun, what do we call that?
So that would be the muzzle.
All right, and you have that. For example, you have, let me make sure I get the right ones. Okay. All right, so that is these 3. Number 4 is the sights and the slide. Number 5 is the handle, trigger, and mag, meaning the magazine of the pistol, correct?
Yes.
And then finally the last one, number 6, is the muzzle.
Correct.
So you have swabs from all over this gun, basically.
Yes.
The other 2, just so the jury knows why we're talking about it, 7 goes to a blue thermos mug, and 8 goes to something called a blue Bubba mug.
Correct.
And you never actually see the actual items, right?
That's correct.
You just see these, I mean, what's in here are basically like kind of long-looking Q-tips.
Yes.
Okay, so you get these Q-tips, that's the swabs, and you can go through a process, and I'm not going to go through all the process, but you can go through a process and you can try and extract the DNA off the swab, and then eventually you can try and compare the DNA that came off the swab to the known sample from a particular person and see if they match or if they don't match or whatever the case may be.
That's correct.
And just to give people the basic primer of DNA, DNA comes from where? Where do people get DNA from?
So almost every cell in your body contains DNA.
So you can get it from blood.
Correct.
You can get it from semen or saliva.
Yes.
You could even theoretically get it from skin,
Yes.
right? You could find a piece of clothing that someone had worn. If there's lots of wear, like the collar of my neck rubbing against the collar, you might be able to get DNA there from my skin cells.
Yes.
Or I could touch an object, even briefly, and maybe leave DNA.
That's correct.
But just because I touch this object, or I touch this object, or I touch this object, is there any guarantee that I leave DNA?
The possibility is there, yes, but there's no guarantee how much.
Okay. So maybe DNA is on an item, maybe DNA is not. We swab it, and then you have to tell us after the fact, yeah, there is DNA, no, there isn't DNA, and I can either maybe tell you who it is, or I can't tell you who it is, or whatever the answer may be. Is that correct?
That's correct.
So, let's work backwards. You did the swab of the blue Bubba mug, okay? And I'm going to show the jury just very briefly. This was admitted into evidence as State's Exhibit number 10. So you got some swab attributed to something called a blue Bubba mug. Now, in that case, you did a sort of special test to determine whether or not there was blood, correct?
Yes.
And explain to the jury what that test is, how it works, and what it can tell you.
So I perform a presumptive test, which is testing for the possible presence of blood. I apply a series of chemicals to the sample, and what I'm looking for is a pink color change, which will indicate a positive test. And in this case, I received a negative test.
Okay. There was negative, meaning there was a suggestion there was no blood.
Yeah, there was no chemical indications for blood.
Okay, but, and again, this is just a hypothetical. If a person was armed with the blue Bubba mug and smashed another guy in the face with it, causing blood to come out of his face, there is the possibility there could have been blood on the mug, right?
I did not see the mug, so I can't answer that question.
But I mean, just in that scenario, because blood is coming out of the person's face who's smashed with the mug, blood could transfer onto the mug, and then you could potentially get DNA off of it.
Your Honor,
Potentially.
objection. Ask that answer.
Overruled.
I'm just explaining, DNA can transfer onto the mug from the blood if that was the scenario.
If that's the scenario, this is correct,
But
yes.
you didn't find any blood or any indication of blood on the Bubba mug.
Correct.
But you did find DNA on the mug
Yes.
from one person,
Correct.
and only one person.
Yes.
And who's that?
So I matched the partial DNA profile to Mr. Lay.
Right. So if that was the victim's mug and he was holding it in his hand or something, it would not be surprising that we might find his DNA on his own mug.
Correct.
There was another mug. There was a blue thermos mug. And I will show the jury what's been marked as Exhibit 8. It's a little hard to see, but maybe if I blow it up here, you can see the words thermos on it. You also checked that mug for DNA. Is that correct?
Correct.
And on that mug, you definitely found that there was certainly one person's DNA on it.
Yes, I developed a partial profile from this evidence.
But even though it's partial, you were able to definitively say if it's someone's, correct?
I did match it to an individual, correct.
All right, and that's the language you use, match. So you're saying
Yes.
this matches a particular person. Whose DNA matches onto that mug?
The DNA matched Mr. Radford.
Radford, okay. So if that was Mr. Radford's mug and he was holding it and drinking from it, not surprising his DNA might be on that mug.
Correct.
But there was an indication that there might be other DNA on that mug, wasn't there?
There was more information in the sample which suggests the possibility of additional contributor. However, it was not interpretable.
All right, and so all you can say is maybe there's somebody's DNA on there. Is that correct?
I'm saying that there was potential information that was present that may indicate a contributor, but it was not interpretable, so I did not compare it to anyone.
Okay. But again, we covered touch DNA can get onto an item from just even touching something, correct?
Correct.
And do you agree with me that in terms of DNA, touch DNA is one of the harder ways to get DNA on an item because it's not like blood or semen where you have like an actual like liquid or substance on the item. You're just hoping something transfers into contact.
Correct.
So would it seem weird to you if I was to suggest to you that a person might have their blue thermos mug in their hand, holding it by the handle, smack another guy on the side of the head, contacting the ear, but it doesn't draw any blood because the blood's on the inside of the ear, that's where the cut happens. And so maybe just a tiny bit of DNA transfers, but not a lot?
It's possible. Again, I was not there, so I can't say.
The next one that you had was the muzzle of the gun. Again, that's the front part here, the hole of the gun, correct?
Yes.
And did you get indications that there was DNA on that muzzle area?
So I was able to develop DNA results, however, they were not interpretable.
Okay, and what does not interpretable mean?
So this DNA profile, during the analysis process, I was able to determine whether it was a mixed profile or a single source profile. There was too limited information to use.
Okay, so you can't even tell if it's one person's DNA or more than one person's DNA on the muzzle, is that correct?
That's correct.
And because it's limited, you can't even tell if it's Mr. Radford or Mr. Lays.
Correct.
If Mr. Radford was the gun owner, it would not be surprising if maybe he might have had a little bit of DNA near the muzzle if he ever handled his gun.
Not expected, yes.
Or if the gun was pointed at Mr. Lay and he was shot, and as a bullet enters his body, maybe a tiny speck of blood leaps up and makes contact with a close muzzle? We don't know, right?
Correct, we don't know.
Okay. So then we get to the grip, the trigger, and the magazine, that I will, for ease of description, call the lower portion of the gun. You were able to find DNA there, right?
Yes.
And you were able to find a specific person. You can again say it's a match to one particular person, the DNA that's there.
Yes, I did match it.
And who did you match DNA to on the handle, trigger, and magazine area of the gun?
Mr. Radford.
Now, if Mr. Radford was holding the gun in his hand and his finger was on the trigger and he had at some point in his life loaded the magazine into the gun, not surprising we would find Mr. Radford's DNA on the handle and the trigger, right?
That's correct.
There is a suggestion, though, there that there is maybe somebody else's DNA?
Again, this is the same as the previous sample. There was additional DNA that was potentially suggesting a possible contributor. However, this, again, was not interpretable.
All right, and now we're going to have to dive into the weeds for just a brief second. I want you to explain to people what is DNA, where it comes from, like how do we get it genetically, like where do we, with all those sorts of things.
So DNA, it stands for deoxyribonucleic acid. You get half of your DNA from each of your parents. 99% of the DNA within our bodies does code for the same information in all people, with the exception of identical twins. The remaining portion of that is different amongst us, and that's where I do my testing.
Okay, and so when you do the testing for like a known sample, like the defendant's known sample, the buccal swab he gave, you end up with basically, for ease of description, like a series or a pair of numbers that tell you like the markers at each of his DNA spots, right?
Yes.
And what do we call those DNA spots?
So the spots that I look at, for lesser terms, they're also known as locations or loci. I look at 21 of these areas. And each one of those areas, you'll find 2 DNA markers for an individual. Each one of those DNA markers represents one that you've gotten from each parent.
Right, so mom gives me a marker, dad gives me a marker, they become a pairing, that forms one of my loci, and people have like millions and millions in their DNA, I think, right? Or whatever the case may be?
Yes.
Okay, but you have 21 that you look at because those are the ones that we use because they're the human, sort of the ones that distinguish us from animals and stuff.
Right, these are the used ones in forensics.
Okay. And so, for example, you might look at a person's DNA profile, you know, and you've got 21, and the first one might be a pairing of numbers. You might have like a 13, 14. That could be like an example, right?
That's correct.
And that's a pair because, for example, just in my hypothetical, 13 comes from mom and 14 comes from dad.
Sure.
And then you might have another one, and that one could be a 16, 19. And then you can even, in some cases, have one where you just happen to have the exact same number at both, 15, 50.
Yes.
Okay, and you get 21 sets of numbers of a pair each, and that's a DNA profile for a person.
Correct.
Okay, but sometimes you can look at a DNA profile, and you might have one little oddity. You might have like a 15, 15, 16, or you might have like a 13, 14, 19. People can't have more than 2 numbers because we always have a pair. So when you see this third number, it suggests maybe there's another person.
When I'm looking at the profile and I've determined that it is a single source profile, again, most people have attributed at each area, you'll have 1 or 2 peaks. So if I see an additional peak, it is most likely a possible additional contributor.
And when you say a peak, that's like a 13 is 1 peak and a 14 is 1 peak? Or
Correct.
Whatever. So in the case of the trigger handle magazine, you got a complete DNA profile from the defendant, Gerald Radford, right?
I did obtain a partial DNA
Or
profile.
you had a partial. How many locations did you have?
So I had 21 areas.
You had 21 areas,
Yes.
okay. And so you had 42 numbers, 21 pairings, is that what you had?
So a partial profile means that there is some missing information from that, the DNA markers in the 21 areas.
Okay, so you might have had 21 areas, but some areas you might have only had like a 13 and not another number?
Correct.
Is that what you mean?
Yes.
Okay, but you got information at all 21 locations, but at one of those locations, did you just happen to get a third number? Did you have, for example, a 13, 14, 19?
I don't remember the number specifically, but yes, that is what you're talking about, correct?
You didn't have a third number at like every of the 21 locations, right?
Correct.
You had one sort of anomaly.
Yes.
And you don't know what that means, right? You can't tell me if that really means there's a second person who touched the gun, right?
Correct.
You can't tell me who that person is.
No.
It could be even something as innocuous as somebody walked by the object and sneezed on it, or was like collecting it and sneezed on it accidentally, or who knows, but the point is, we have no idea what that one random anomalous number is, right?
That's correct.
It's not saying there's definitely a second person touching the trigger.
Correct.
Okay. So the only place where we have a mixture, and tell the jury what a mixture is as opposed to a single source profile.
So a mixture is a profile that is from more than one individual.
Okay, and so if, for example, in some sort of weird universe, Mr. Cruz and I both decided to cut ourselves and bleed into the same spot, the blood would mix, and then if you swabbed it, you would expect to find a mixture of Mr. Chambers and I.
Yes.
Okay, and I called it Mr. Cruz again, I apologize. That's a mixture, a place where two people's DNA have sort of overlapped in the area.
Correct.
It doesn't tell us why they overlapped.
That's correct.
It can't tell us what they're doing at the moment that they overlapped.
Correct.
Okay, so if I was to touch this gun and then let you touch the gun, there would potentially be a mixture of our touch DNA.
Yes, it's possible.
But it doesn't tell me whether or not you were holding the gun and I was trying to wrestle it away from you. It doesn't tell you whether or not I'm holding the gun and you're trying to wrestle the gun away from me, right?
Correct.
All it can tell us is maybe some other person touched this object, but not what they're doing, when they did it, why they were doing it.
That's correct.
Okay, so on the top of the gun, the part that you have to pull back to rack and make it so it shoots, whose DNA did you find on the top of the gun? The sights and the slide.
So the sample itself was collected to be sights and sights and slide. I
Right.
don't know how the crime scene individual may have collected it. Was it from the sights first, or from the slide first? I'm not sure.
I got it, but it came from somewhere up here on the top part, the part that you use to make a semi-automatic gun ready to shoot.
Correct.
Whose DNA did you find?
So I was able to include Mr. Radford as a possible contributor to this mixture.
And there I noticed you don't use the word match.
Correct.
Why do you use the word include as opposed to match?
So match refers to a single source profile, so I'm saying DNA profiles are consistent with one another, as opposed to a mixture. I'm comparing an individual's DNA types to the mixture, so I'm including their DNA types in the mixture.
Right. Since it's a mixture, again, to go back to my scenario, you might again have the 13-14 and the 16-19 and the 15-15, but the problem becomes you're also seeing like 17-12 and you're seeing 13-9 or whatever it is. There's too many numbers to be one person.
Correct.
And you have such a repeat of that, it's not just one anomalous instance, there's multiple instances you can say this is definitely at least two people.
Correct.
Now, beyond the ones where we have numbers, do we have DNA markers that are assigned letters? Like an X and a Y?
Oh, I'm sorry. Yeah, so I do look at gender determination markers. One of them does have an X and a Y. It's determining whether or not someone is potentially biologically male or female.
Okay, and so I want you to explain to the jury, if you see, what's the male one?
It would be an XY.
So if you see an XY, you know that definitely one of the people in the mixture is a man.
Yes.
But in my scenario, you're obviously a female, I'm a male. If we both touch it, you'll see an X, but you don't know, other than if you saw it, you don't know if it's a man and a woman, or if it's like Mr. Chambers and I, it's two men touching it.
Yes, well, if the Y is present, I will determine that there's at least one male present.
Right, that's what I'm saying. You can
Correct.
tell at least one, but you can't tell if that's, when it's two people, you can't tell if that's man and woman, or if it's man and man.
Correct. Correct.
Okay, so the fact that there is the defendant's DNA on the gun, and the fact that the defendant is male, it's not surprising you saw the indication of at least one male.
Correct.
But if the defendant, for example, had a wife and maybe his wife once picked up the gun, we couldn't tell because we don't know if it's man and woman that touched it or man and man that touched it, right?
I would also need buccal swabs for comparison.
Sure, I got that. But I mean, just looking at the sex chromosomes, you can't tell.
Correct.
The X's and the Y's.
Yes, correct.
Okay. So we know for sure, well, we don't know for sure. You said he's included. But when you do an inclusion, are you trained to do statistics?
Yes, statistics are calculated.
And when you do statistics, what are you trying to calculate? What is it telling us when you're calculating statistics?
So I'm trying to tell you how likely is it to occur if an individual is included in a mixture versus someone unrelated.
And I know that you have a very specific language you use because you're a scientist and I'm not, but when you're talking about likelihood, you're talking about the chances that the DNA is coming from one particular person as opposed to any other person. Is that a fair description?
It's a fair description, correct.
Okay. And so I want you to tell the jury what is the statistical determination you came to regarding the chances that it's the defendant's DNA on the slide of this gun.
So the observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample, excuse me.
Did you say 700 billion with a B?
Correct.
How many people are on Earth?
8.5 billion, I think.
Okay, so I gotta have more than 50 Earths to get to the chances of having somebody else who have the same DNA as you found on this gun and it being the defendant? Is that what you're saying effectively?
So my statistic doesn't refer to the population of the Earth. This is just a segment that FDLE uses in our reports. It shows that the number I do have in my file is much larger than that.
Okay, I got it. But I'm trying to figure out a way. I mean, the average person doesn't walk around counting to the billions or, collecting dollars in the billions. It's a number we don't. So I'm trying to put it in reference. There's 8.5 billion people on the planet, and you're saying 700 billion for the chances it's the defendant's gun, on the DNA on the gun?
Greater than 700 billion.
Greater than. Oh, okay.
Correct.
Thank you. So it's a mixture. We got a pretty good indication it's the defendant's DNA on the slide of the gun. Can you tell me who the other person in the mixture is?
So I was unable to make a determination to Mr. Lay to this item, and I had no other reference standards to compare.
Well, you did have a reference standard from the victim, Mr. Lay, right?
Correct.
And you can't do what's called include or exclude him.
Correct.
And so maybe he's there, but also maybe he's not.
So yes, there was no statistical support to either include or exclude Mr. Lay.
So we have no idea who else's DNA is on this gun other than maybe Gerald Radford's. We have some indication of some person, but no idea who it might be.
Yes, I had no other references to compare.
But in fairness, if the victim was fighting with Mr. Radford over the gun, he could have left touch DNA if he's touching the top of it. Correct?
It's possible.
But you again can't tell if that's because the victim is the one holding the gun trying to shoot Mr. Radford, or if Mr. Radford is trying to shoot the victim and the victim is fighting over the gun trying to not get shot.
No, I can't tell you that.
Thank you, ma'am.
Thanks.
Anything else? All right, you can step down, ma'am. Thank you. Is she released from her subpoena?
Yes, Judge. Yes, Your Honor.
All right,
All right, thanks, Your Honor.
thank you.
Defense would rest, Judge.
All right. The offense is rested. Anything else from the state?
No, Your Honor.
All right, we're gonna take a quick recess. All rise.
All right, state rested. The state rested. So while they're going to go on, I guess now to closing. So Maureen Meehn, crime lab analyst, basically a DNA expert. The bloodstain card from Lay, buccal swab from Radford. She analyzed the gun. But no determination was made for Lay. Then she looked at the blue Bubba mug. DNA was there, but it wasn't interpretable. She couldn't tell whose DNA was on the muzzle. She analyzed the handle, trigger, and magazine. The DNA was Radford's. There was additional DNA there, but it wasn't interpretable. Top of the gun, which is the sight and the slides, Radford's DNA was there. It's kind of okay. So the whole point of that, I guess, is they said. Radford said he pulled the gun out and then Walt grabbed him and he was struggling with the gun. So Walt's DNA should have been all over that gun as well. Sounds like it wasn't. So that kind of blows the theory of Mr. Radford saying that Walt grabbed the gun. So, I don't know. What do you guys think? I'll put up a poll. Did the state prove it? Let's do a poll. Did the state prove it? All right, there is the poll. I'll say new poll chat. New poll chat. So there you go. Did the state prove their case? I have to think about that. Did the state prove their case? Is Mr. Radford guilty or not guilty? All right. Let's get to, I guess we're going to get to closings. Here we go with closings.
Testimonial evidence, but please listen.
Sorry about that. Comes in hot. All right. Closing arguments. Here we go.
Testimonial evidence, but please listen carefully. Final arguments are intended to tell you how they believe the law that I've just read to you applies to the facts that you've heard during the course of the case. Of course, if their version of the facts differs from what you understand the facts to be, I'm going to ask you to rely on your memory. You are the fact finders in the case, not the lawyers. Both sides have equal time to address you, but because the state does have the burden of proof, they're entitled to go both first and last in their remarks to you. Mr. Diaz?
Thank you, Your It's 1932. It's Game 3 of the World Series, and the great Babe Ruth steps up to bat. There is a moment in the folklore of American baseball that Babe Ruth, as he's standing in the batter's box, looks to the outfield, points to a particular spot. Shortly thereafter, he smacks the hell out of that baseball. The great Bambino, a man so prolific at hitting home runs, he's known as the Sultan of SWAT, the guy who held the record for hitting the most home runs for nearly 4 decades, sends the ball sailing over the outfield wall, right where he pointed. It's called the called shot. Now, why am I talking about baseball? Gerald Radford called the shot. For days and weeks and months, he told us where it was going. And just like any person seated in the ballpark in 1932 might have thought, he can't possibly be suggesting exactly where the baseball's going to go, Gerald Radford called the shot. Now, I'm going to talk with you in a few minutes about why Gerald Radford is guilty under the law. I'm going to show you the instruction. But I'm going to ask you first and foremost to just use your common sense. Gerald Radford said a hateful homophobic slur, fucking faggot, over and over, to the man's face. He said it in front of others. He's so brazen, he said it to Mr. Genovese, who he hadn't seen for 3 years, and was just trying to have a polite conversation, and on his own, he just immediately switches and goes into angry, hostile mode to basically a stranger. But the week before, he's sitting at the dog park. He can hear the victim coming up the road because the victim's dog is barking. There's Vicky Darlington. There's that fucking faggot. I want to kill him. That's 7 days before he kills him. When he's with Mr. Genovese, it's just hours. It's less than 24 hours, and he's bragging about how much glee he takes in trying to walk up on the victim, get in his face, and scare him. And he's doing that, arguably, after he has been at the dog park and Mr. Lay has filmed the selfie saying Mr. Radford has yelled at him, "You're going to die. You're going to die." Gerald Radford is standing at the batter's box at the World Series, and he's calling the shot. 24 hours before Mr. Lay is dead, Gerald Radford is telling him, "You're going to die." When you go back, you have obviously already had the instructions. None of this will be a surprise to you, but I want to highlight some of the instructions to make sure that there's no misunderstanding. The first one is, your verdict must be unanimous. And what that means is, on every single one of those places where you have to check something on the verdict form, you have to all agree to that decision. Okay? But why you agree to that decision doesn't necessarily have to be exactly the same. You might believe one witness was more persuasive than another. You might believe one fact is more persuasive than another. In a second, when I get to hate, ill will, spite, evil intent, one of you might call it hate, one of you might call it spite, one of you might call it hate and spite, one of you might call it evil intent. The point is, you believe that that element has been proven. You don't have to be unanimous as to why you think the case has been proven beyond a reasonable doubt. You just have to be in agreement that the case has been proven beyond a reasonable doubt. That's what unanimous means. Do not let bias, sympathy, prejudice, public opinion, or other sentiment. I want to be clear. I've stood up here and I've said some really harsh words. Because I want you to recognize that those words are harsh. They are hateful. Okay? But we're not here to punish Gerald Radford because he happens to be a conservative. We're not here to defend Walter Lay because he happens to be a liberal. Whatever your opinion is on all those topics that they argued about, whatever your opinion might be on whether or not gay people should have rights and whether or not you should be allowed to get married, it's not what we're here for. Okay? But we are here to determine whether or not that man had hate in his heart for another person because he's gay, and killed him because he's gay. If you return a verdict of guilty, it should be for the highest offense. When you see the verdict form, you'll notice that there's an A, second-degree murder is charged, B, manslaughter, that's called a lesser included offense, and C, not guilty. Those things are arranged in the highest order of offenses. The A is as charged, the lesser, and then the not guilty. Okay? And it's sort of the same thing for the other ones beneath it, the questions, but they're all, some of them are independent questions and they're not. Long story short, I submit to you, you're going to check second-degree murder because the state has proven it, and then you're going to check yes all the way down. Because that's what you should do, because the state has proven the offense, we have proven to you the defendant is guilty, and you should. Not you can, not you might, not you may, you should find him guilty of the highest offense that has been proven. So I want to talk with you about obviously the charges, because that's the part we haven't talked a whole lot about. And so you've seen these instructions in Introduction to Homicide, and this is where you now realize that there's actually something called manslaughter. It's a lesser included offense. And the way I always teach lesser included offenses to young lawyers or people who aren't lawyers is, just think of a burger. What is the base idea of a burger? It's top piece of bread, piece of meat, bottom piece of bread. Right? Those are like the elements of hamburger. And if I tell you cheeseburger, it's still just top piece of bread, piece of meat, bottom piece of bread, but you add something extra, you put a piece of cheese on it. And the difference between second-degree murder and manslaughter you're going to see is just the ill will, hatred, evil intent response. That's the cheese on the cheeseburger, as it were. You've seen this instruction, and you're going to sort of see the word justifiable appear in two places. We're going to get to the other one, the longer one, in a second. But I just want to point out, there's one part that's the attempt to murder or commit a felony, and we're going to talk about that under the justifiable use of force. That's the same concept. But this clearly did not take place in anybody's dwelling house, right? It's in a public park, so that part doesn't apply. You can't get to justifiable there. And I submit to you, you can't get to excusable either. Because every single instance of excusable requires an accident and misfortune. And misfortune. It's got to be both. First off, it's not even an accident. The defendant has told us repeatedly he turned the safety off and pulled the trigger. It's his finger on the trigger. This is not a suggestion the gun went off by accident. This is not a suggestion he was trying to shoot a snake and it hit a rock and took a weird bounce and it hit the... None of that. It's not an accident. So there's no excusable homicide here because every single one of these fails automatically just on is there an accident and misfortune, and there's not. So I'm going to work backwards. I'm going to start with hamburger, as it were. These are the two elements. John Walter Lay is dead. Ladies and gentlemen, sitting over there is a stipulation. You will take it back with you. The judge has told you, you must accept that fact as true. The defendant and the state have stipulated John Walter Lay is dead. Even if you don't believe Dr. Devers, for whatever reason, the defendant has told you, I agree, he's dead. The element's proven. Gerald Radford intentionally committed an act or acts that caused the death of John Walter Lay. He said it. It's his finger on the trigger. He pulled the trigger. He's told you that. I told you from the very outset, the first part of every self-defense claim is, I did it, but ... right? And we're going to get to the ... But he told you he did it. And if you don't believe the part that comes after the but ... what you're left with is, he did it. Gerald Radford has told you he committed a manslaughter. The only question is there a justification? Is there a legal reason to excuse and justify what he did? And you'll see it's not a merely negligent act. Well, it's definitely not a negligent act. He told you he did it on purpose. It's an intentional act. Negligent is a difference from intentional. Okay? And here, I don't have to prove that he intended to kill him. Because that would be first-degree murder, because you're going to see that same sentence in a second in second-degree murder. Okay? I'm not suggesting that Gerald Radford sat at home, planning, calculating, loading his gun in the morning, putting bullets in it, thinking like, today's the day I'm going to kill that fucking faggot. Okay? That would be first-degree murder. That's intentional. There it is again. This is second-degree murder. There's the same sentence. And if you think about it, elements 1 and 2 are basically the same thing. Is John Walter Lay dead? Yep. Was the death caused by the defendant? Yep. So the only question is that weird lawyer talk. An act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And there is a definition, because if you had to guess what that means, you'd probably argue amongst yourselves all day. But I submit to you that 1 and 3 of the definition are painfully obvious. Is pointing a gun at another person's chest and firing a bullet in it reasonably certain to kill or do serious injury to another? Yep. Is it of such a nature that the act itself indicates an indifference to another human life? Yep. All that's left is ill will, hatred, spite, or an evil intent. And that's why at the start of this trial, I stood in front of you and I submitted to you that there's really one question you have to fundamentally answer. What was in the mind and the heart of Gerald Radford when he killed the victim? Was it fear? Or was it hate? Now, as part of the verdict form, you obviously don't just pick A, B, or C. There's all these other questions you have to answer. And that's why you have these other instructions. Okay? Did Gerald Radford carry, display, use? Well, he definitely carried, and he definitely used. And you can argue amongst yourselves about whether or not he carried and he used, or he carried, or he just... The point is you don't have to be unanimous again. You just have to think that one of those things happened. But I submit to you that at a bare minimum, carried and used both happened. Did he possess a firearm? Yep. Did he shoot the firearm, aka discharge the firearm? Yes. Did the discharge cause the death? Yes. These are instructions for all these things. But once you decide that Gerald Radford has committed second-degree murder, that he's not acting in self-defense, the answer is going to flow. And the answer is going to flow here. Again, there are two elements. Did Gerald Radford perceive, know, or have reasonable grounds to perceive and know? He knew. He told you he knew. He told you the victim, who's a gay man, asked him out for a beer, and that's where it all unraveled. And he knew what that meant because his answer was, I'm married and I'm straight. So he definitely knew the victim was gay, but I mean, there's tons and tons of evidence. That's not the question. The question is intentionally selected. And I need to be clear. It says intentionally selected, but you notice it doesn't say intentionally physically selected. Okay? Gerald Radford can mentally select the victim. He can verbally select the victim. And he did. Over and over again. That fucking faggot. I'm not going to start the fight with the gay guy. Okay? He picked John Walter Lay. You heard it. Look at all the people that came in. All the people that called Gerald Radford an asshole. All the people that said they didn't like him or even hated him. All of the people that scolded him for his behavior. None of them said he was really mean to them. None of them said he really had a problem with any of them. They're certainly not the ones who are dead. So, this is self-defense in the state of Florida. We call it the justifiable use of deadly force. And you will notice that in this case, there's no instruction for the use of non-deadly force. There is actually a separate instruction for non-deadly force. Mr. Futch talked about that during jury selection, if you remember. Because a person can defend themselves in non-deadly means. But in the state of Florida, it turns out the minute you pull the trigger, it's always deadly force, which is why you only get the deadly force instruction. Okay? Gerald Radford could have defended himself by punching or kicking or biting or pushing or pulling, and he would have had a great argument for non-deadly force. But that's not what happened. He pulled the trigger, so this is the standard. This is what he is judged by, what the state has to prove to you didn't happen. And I submit to you that right there, that's the magic words. That's the what's in his heart, what's in his mind. Fear or hate. Because you have to reasonably believe that you're going to suffer either imminent death or great bodily harm or a felony. In this case, felony battery. Right? Which again, if you just read felony battery, right, it's causing great bodily harm, permanent disability, or permanent disfigurement. It's basically just this again. He's got to think he's going to die, or he's got to think he's going to get maimed. He's got to think he's going to get put in a wheelchair for the rest of his life. He's got to think he's going to get scarred up. He's going to get mangled. He's got to reasonably believe that, not possibly. Right? Because remember, we've talked a lot about reasonably. He's got to reasonably believe he's going to die, or the victim is going to mangle and maim him. None of that is the case. And if you don't think he had a reasonable belief of imminent death or great bodily harm, he's already not acting in self-defense, not in the use of deadly force. But I submit to you that if you just keep moving down, you'll see other reasons why Mr. Radford's claim of self-defense doesn't hold water. Okay? Mr. Radford, I submit to you, was committing an assault or battery. And I know we're going to talk in a second about the defense is going to suggest, no. John Walter Lay is the one who started the fight. He's the one that committed assault or battery. But I submit to you that Gerald Radford is. And if he is, because look, he's definitely in a place he has the right to be. You see number 2? He was in a place he had the right to be. It's a public park. We can all go there. So I'm not suggesting he's in a place he doesn't have the right to be. But he has to be in a place he has the right to be, and he has to not be committing an offense. Okay? And so I want to show you something that we have not talked about, because I saved it for this moment. This is the walkthrough from State's Exhibit number 16. That's the wrong thing, sorry. Do you remember what happened when the schism broke out? When the group separated? Where did Walt go? Where did Mr. Lay go? They tell you that he went to the picnic bench on the other side of the water trough? Did he tell you that that's where he always went? Did they tell you that any person who was in the park would have realized that John Walter Lay was coming because his dog would have been barking its head off coming up the street? Because if they did, and if a guy is standing alone in a park, 5 acres of a park, and he knows that John Walter Lay is coming because he hears the dog barking, he knows where John Walter Lay is going to be. Right here. You see it? 108. It's the picnic bench. You hear the detective, he's asking, where are you standing? He's about to tell you where he's standing when the victim is arriving at the dog park. Look where he's pointing. Picnic bench. And watch. In just a second, he's going to stand in front of the picnic bench, and he's not going to be right next to it. And then he's going to say, oh no, I was more like 20 or 30 feet back.
Okay. Alright. Okay. So he gets here, and what path do you take when you're walking towards him?
Walking back towards the table.
Okay, so let's do it. Alright, so we're walking.
And he's walking this way, and he comes walking over here.
Okay. So where do you guys first make contact with each other? Where do you think there's people?
I don't have the time, Sam. I apologize. Go back and watch it yourself if you don't believe me. But you're going to see he's going to motion back at the picnic table. Okay? He's laying in wait. He's going to have another round. Gerald Radford has all the hallmarks of the bully in this indication, in this situation. He gives every indication. He's hostile, he's belligerent, he's threatening, he's confrontational. And he's waiting. He's in the spot. It's not like he needed to stand there, because he even says, when the guy comes in, right, he starts to move towards the water trough. He's going towards the victim. Because he knows what's coming. The same thing that's always coming. He's going to get to have the fun of having the argument. He's going to have the fun of getting to intimidate and bully and disrespect and throw out a few homophobic slurs. That's what he's going to get to do. And that brings us to this instruction. Gerald Radford cannot claim self-defense if he's the one who initially provoked the use of force. And this is interesting. I want you to pay attention, because here it says the use of deadly force is not justified if you find that Gerald Radford used force or the threat of force. You can't pick a fight. Start getting your butt whipped in the fight you picked, and then pull out a gun. Unless the force is so great that, again, he thinks he's in imminent danger of death or great bodily harm. If I want to have a fist fight with a guy and I start a fist fight, and in the middle of the fist fight he pulls out a knife, well, he's just changed the terms of the fist fight, so I can draw the gun. Because now he's got a deadly weapon and I'm going to get my deadly weapon. But the victim didn't have a deadly weapon. Gerald Radford wasn't in fear of death. And how do you know that Gerald Radford wasn't in fear of death? These timestamps are from the audio portion, because it's easier to hear. You can go watch the video portion and you'll find it too, but go to 30 minutes and 42 seconds of the first interview with Detective Herrick. and you will see the question. During this incident, when you in fear, what's fear? I didn't want to get my ass kicked. Yeah, I thought he was going to kick my ass. And I know the defense is going to tell you in a minute that kick my ass means that Walter Lay was going to maim and maul Gerald Radford. But you can decide whether you reach that conclusion too. During this altercation, at any point were you in fear for your life? Well, after I got blood on my face, I was kinda scared. No person who thinks they're going to die, who thinks they're going to get put in a wheelchair, maimed or mauled, is kinda scared. A guy who's in a fist fight, he's kinda scared. But a guy in a fist fight can't pull a gun and shoot the other guy. I should have just let him kick my ass and be done with it. That statement makes no sense in the context of what Gerald Radford is claiming. Gerald Radford is telling you that if I didn't draw this gun, if I didn't defend myself, I was going to die or get maimed. No person would say I should have just let him keep going. No person. Except a person who erroneously thinks that the law says that if a person puts their hands on you, you can immediately draw a gun and shoot them. Because that's what Gerald Radford thought. And that's exactly why, as time goes by, Gerald Radford has to keep adding facts. He has to keep changing facts. He has to keep making it sound more egregious what was happening to him. Because as the case is progressing, as the investigation is progressing, he's realizing a fist fight just doesn't do it. I just needed him to stop beating me up. That's what I needed. Nobody describes being in danger of death as I just needed him to stop beating me. He would say it. I thought he was going to kill me. I thought I was going to die. And you will not find those words anywhere in the first interview. You won't even find them until the third interview. We start to get to that. But remember, by the third interview, he's now seen the video of the victim. If that's the only way John Walter Lay gets any word in this trial, because the dead don't get to speak. But he's realized that John Walter Lay is speaking from the grave. You're going to die. You're going to die. Gerald Radford is standing in the batter's box and he's calling the shot. Ladies and gentlemen, you've all paid really good attention. I've seen many of you taking pretty meticulous notes. I don't think anything I'll have to tell you is a secret. I submit to you that the defense is going to try and do anything but draw your attention to Gerald Radford and the hateful words that he used. And they're going to do that by trying to point in three different directions. The first is State's Exhibit 18. I'm not disputing that these are the words of John Walter Lay. I'm not disputing that he wrote them on the day before he was killed. I'm not disputing that the words are what they are. But words matter. That wasn't me. That was Mr. Futch, over and over. Words matter. And that's an if. If he tries to block my path again. The first thing that tells you is Joe Radford has blocked his path before, which is completely consistent with everything you heard from the people at the dog park. If he blocks my path, then I'll try to tackle him. And I know the word then isn't there, but that's what it is. It's an if-then statement. That's how logic works. If this happens, then this will happen. Maybe. Because you can also decide that John Walter Lay was just talking trash. But even if you believe it, look at what he says. I'll try to tackle him. Not I'm going to try to kill him. Not I'm going to try and cave his head in. Not I'm going to pound his face into the concrete. Not I'm going to snap his legs, break his nose. None of that. He's going to try to tackle him. So, even if you think that this is any indication that John Walter Lay had really reached the point that he was going to turn the fight physical, he was going to start a fist fight. He wasn't going to try to kill Mr. Radford. He wasn't going to try to maim him and put him in a wheelchair. And it doesn't even make sense. Joe Gerald Radford doesn't even tell you that what happened to him is he got tackled. I mean, no matter which story of Gerald Radford you pick, and there are several, he either has Mr. Radford, Mr. Radford either has Mr. Lay in his face, and the two men are basically arguing face to face, because in the first interview, Mr. Radford even says to Mr. Lay, "What are you going to do?" Or if you believe the other version of events, which comes way later, now he's getting ambushed and blindsided, it's still not a tackle. If this is the plan, if this is the announcement, if this is John Walter Lay calling the shot, he didn't even hit the ball. And you have to believe that that statement overrides the months, the days, the weeks, every instance that Gerald Radford telegraphed what was coming. So that's the first one. Point the attention at Mr. Lay. Don't look at Mr. Radford. Where's the second one? Detective Harris. Point the blame, point the attention at Detective Harris. Now, I want to be clear. Do I wish I had a video of it? Sure. Make my job a whole heck of a lot easier. And they're going to just presume, because that's what Mr. Futch did in every instance. He just presumed that if we had gotten the video, it would have exonerated, it would have proven Gerald Radford innocent. Whatever that's based on. Nobody knows what's on that video. It's just as likely it could have been damning to Gerald Radford as it could have been exonerating to Gerald Radford. But, to at least try and give you some indication, law enforcement took the time to go back, to watch the live feed, to put a person in the park, to try to see what the camera likely would have shown. And Detective Harris told you, it's tiny little people. And so if we had gotten the video, and if we could reasonably conclude, and I submit to you that you can, that it probably wasn't going to really answer the question of what happened and when and why, you would still have to make the decision based on the evidence that's in front of you. And that's what I submit to you you should do. Yeah, things could have gone better. Sure could have. Don't doubt that. That doesn't mean that Gerald Radford is not guilty in the light of every other thing he did and said, and the fact that nothing Gerald Radford described about the initial fight comports with what Dr. Diaz and medical science told you. He doesn't even get the right place. Here versus here. He's telling you it's in left field, but it's in right field. It's not the same place. So who's left? If you don't decide that it's the fault of Mr. Lay, if you don't buy into the victim blaming, because I expect that you have also been suggested that, why didn't John Walter Lay just stay home? Because that's what happens. People should live in fear, and they should have to give up the places they want to go in life and the places they enjoy because somebody bullies them, I guess. Or if you don't buy into it's Detective Harris, the final place is the State Attorney's Office and the citizens of Hillsborough County. Because make no mistake, Miss Bailey stood up here at the opening and used the word railroaded. Right? Gerald Radford isn't the killer, he's the poor victim. He's being railroaded. People have called the media, they have gotten the attention of the media, they have done that to pressure the State Attorney's Office, and the State Attorney's Office has somehow caved and charged the otherwise completely innocent Gerald Radford with murder, because I guess we don't have anything better to do. So we're the bad guys. The people who loved and cared for their friend and watched the abuse and watched the hate that he endured, they're the bad guys. Detective Harris, he's the bad guy. John Walter Lay himself, he's the bad guy. And if that doesn't work, Ms. Bailey also stood up here and tried to suggest that this is somehow a First Amendment case. She just stood at this podium and said when she was younger, everybody just called each other gay and it didn't mean anything. Well, first off, Gerald Radford didn't call John Walter Lay gay. He called him a fucking faggot. Okay? You can call someone an African American, or you can pick another word. You could call someone a Jew or a Muslim, or you could pick another word. What does the word mean when you pick the word? Because, look, Gerald Radford tries to tell you that he's a product of a bygone age from a different place. He grew up in New Jersey, and that's the way it was. Albert Darlington is a guy who spent his whole day on a boat with guys fishing, and even he's like, you can't do this. It's 2024. How completely oblivious does Gerald Radford have to be to look a man in the face, a gay man, to call him a fucking faggot, to have Miss Wolfley, to have Mr. Darlington, and probably other people all tell him, buddy, you can't do that, and to keep doing it? Who gets arrested for a charge where you've been alleged to kill someone because they're gay, and then to get on the phone and cavalierly say, there's gay people and there's fags. Gay people, they're normal people. They have a spouse, they go home, they mind their business. You're a fag. And he didn't just say he said it. He said it to the face of John Walter Lay. Now, I want you to remember something. We read in the testimony of Mr. Radford from a previous hearing, December 6th, 2023. This event was February 2nd, 2024, not 2020, forgive me. February 2nd, 2024, December 6th, 2024. That is 10 months apart. And that's the first time, December 6th, that Gerald Radford finally decided he wanted to volunteer the truth. We had a falling out because the gay guy asked me out for a beer, and I didn't like it. That's what he said. I know Mr. Futch and Ms. Bailey have tried to suggest that Mr. Radford was suffering a concussion and didn't remember what happened and couldn't relay the details and couldn't spell his own name, but you can watch that first interview, you can watch that walkthrough, and he sure seems to know where he is, what he's doing, he sure seems to remember details pretty well, doesn't have any trouble walking, doesn't have any trouble seeing, doesn't have any trouble maintaining his balance. But they suggest he had a concussion, and that's why facts came along. Facts came along. But the fact that John Lay was gay, that didn't come out in the first interview. It came out in the second interview. Because by then, the neighbors, the people at the dog park, had started sounding the alarm. And when Mr. Radford was confronted with that, did he remember, oh yeah, we really had this problem, I should probably tell you, he asked me out one time, I didn't like it. That was a dispute. When we got to the third interview a month later, and now he's been going to therapy and his memory's returning, does he mention it then? It takes 10 months for him to finally volunteer the truth. That's what he did. That's what he said. Ladies and gentlemen, I wish John Lay was here. I wish John Lay could tell you what happened that day. I wish the dead could speak from the grave. They can't. I asked you at the start of the trial when we were doing jury selection, did the word of one person convince you? And I confess I don't have an actual eyewitness except for that man. That man. Gerald Radford. And if you just look at what he's saying, if you just look at when he's saying, if you just make reasonable conclusions and use your common sense about why a person might be inclined to spin the facts one way or another, if you just consider what he absolutely admits to, the victim is dead, and he's the one that pulled the trigger, and compare that against the things that are cold, hard facts, like the autopsy, there is only one answer here. The victim is dead. Gerald Radford killed him, and Gerald Radford was a hateful, spiteful person. He committed second-degree murder. He did it by carrying and using a weapon. He did it by possessing, by discharging, and by causing the death with that weapon. And he did it against a man he had always targeted because he's gay. Gerald Radford is guilty. And you should. I suggest that justice demands that you must find the defendant guilty as charged. Thank you.
Is there a way to hook up to the computer, or do I need to put on the flash drive? I have put the flash drive.
Okay. Here, the flash drive.
Good morning, members of the jury. This weekend should be drama. What took place on February 2nd, 2024 was absolutely tragic. It altered the course of two individuals' lives, changed them in arguably the worst way anybody could imagine, but not just them, their families, their friends. Nobody that has followed along with this case in any way, shape, or form would disagree with the tragedy that took place on February 2nd of last year. These are some of the last recorded words that we know Mr. Lay ever shared with me. This weekend should be drama. Now, when Miss Bailey stood before you Tuesday morning and told you that there were two sides to every story, she was right. But prior to hearing from Miss Bailey, you heard from Mr. Diaz, who told you the state's version of a story. And with his best efforts, he tried to meticulously paint a picture that fit their version of the evidence. And I am thankful that he acknowledged it today when he stood before you in closing, that one of the first things he said to you, in fact, the first thing he stood before you and said was fucking faggot. There's gay people and there's fags. I want to punch him right in the face. Those are the first words that he said to you. Now, he tells you that you're not supposed to use emotion or thoughts about what the public think about this case or bias. And if you recall to jury selection, prior to swearing the oath to follow the law, we discussed this, and you all agreed that no matter what you thought about hateful speech, that in and of itself, somebody using hateful words, no matter how society views that, no matter how inappropriate that might be, no matter how offensive those words in 2024 and 2025 are, that in and of itself, somebody that uses hateful terminology or is a self-described asshole does not make them a criminal and does not make them a murderer. I submit to you that while the testimony and evidence, and there's no dispute that those words were used, there's a reason why Mr. Diaz led them. And now you promised and you took an oath in the law that Judge Ward is going to read to you and has read to you and that you will take back to the jury room requires that you not act on emotion. And I submit to you one step further, that before you consider the language that Mr. Radford used, fag or faggot, before you can even address whether or not he hated Mr. Lay because he was gay, you have to find that he actually committed second-degree murder. Because it is an enhancement. The state is alleging that he chose, that he selected Mr. Lay to kill because he was gay. So his political ideology, his view of somebody that's gay or somebody that's homosexual, that only becomes relevant once you find that Mr. Radford in fact committed murder. And I submit to you that after you heard Mr. Diaz opening, before Ms. Bailey said a word, you probably thought to yourself, disgusting. You probably felt a sense of dread. But the reality is, now the state is trying to frame the evidence in a light that makes it look like Mr. Radford committed murder. But the reality is, and I submit to you, that there's more than two sides to this story. There are a myriad of ways that you as the jury could interpret the evidence that is presented to you. But Ms. Bailey got up and told you a different story. She told you a story about a man that grew up in New Jersey, originally from Ireland, and grew up using language like that. And admittedly, it's offensive. But after hearing all of the testimony and all the evidence in this case, I submit to you that the only conclusion is that this is a case of self-defense. But you don't have to find that this is just a case of self-defense from the standpoint of, is Mr. Radford guilty? Because I'm sure that after sitting through all of the testimony and sitting through all of the evidence, you've asked yourselves, now I submit to you we know what happened, that it was self-defense. But you may have asked yourself, or said to yourself, I don't know what happened. And that'd be perfectly reasonable. Because remember, it is the state's burden in this case to prove to you, each member of the jury, unanimously, beyond and to the exclusion of all reasonable doubt. Not it's possible he did it, not I think he did it, not he might have done it. All reasonable doubt that Mr. Radford is guilty of second-degree murder and that he selected John Walter Lay because he was gay. You promised to follow the law, and Mr. Diaz showed you the instruction, but I'm going to show it to you again. Well, I'll read it to you again. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision in any way. Your verdict must be based on the evidence and on the law contained in these instructions. Now, as I walk you through why the state hasn't met their burden of proof today, there's a few things that I want you to be mindful of. First, reasonable doubt. And I bolded some of this. It's not bolded in your instruction. Reasonable doubt, first and foremost, Gerald Declan Radford has entered a plea of not guilty. This means you, as we discussed in jury selection, and everybody swore they would follow the law in this case, that Mr. Radford is presumed innocent. This presumption stays with him as to each material allegation in the charging document and through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. And that it is the state's burden to prove that. We talked in jury selection about an abiding conviction of guilt. We also talked about how if you do not know, if you say to yourself, well, the state is asking me. Because the state wants you to fill in gaps that exist in this case. There are gaps, there are holes, and we are going to talk about all of them. And Mr. Diaz is right in some context as to some of the things we're going to discuss. And I'm sure before he even told you some of the items I might touch on today, you've been thinking about those things yourselves. Because some of the testimony you heard from Detective Herrick and some of the civilian witnesses is troubling about how this investigation unfolded. But at the end of the day, if the state is asking you to fill in missing puzzle pieces, that is a reasonable doubt. If the state is saying to you, well, speculate as to what may or may not have been on that surveillance footage that Detective Herrick failed to attempt to get for 18 days after a homicide investigation began. They're asking you to imagine what they might or might not be missing. Reasonable doubt. Now, reasonable doubt, and it's cut off here at the bottom, the font changed when I plugged it in here, may arise from the evidence, from a conflict in the evidence, or from a lack of evidence. So please keep that in mind as we go through this. Justifiable homicide. This is something else I want you to pay close attention to. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. And I added Gerald Radford. So in this case, if you think or don't even know, if you say to yourself, well, it's reasonable, it's possible, it's likely that Mr. Radford's story makes sense, that the physical evidence supports it, the injuries to his face, the gash into his nose, and we're gonna look at those pictures. Somebody hits you over the head with a mug, your glasses dig into the bridge of your nose and fly off. Injuries are consistent. Get tackled to the ground. It would be justifiable if he is committing a forcible felony, in this case felony battery, upon Mr. Radford to defend himself with deadly force. I also want you to keep in mind that when it comes to justifiable use of deadly force, I'm trying to fix this real quick. That Mr. Radford still doesn't have the burden. Mr. Radford doesn't have to prove to you that he was justified in doing it. The state has to prove to you beyond and to the exclusion of all reasonable doubt that Mr. Radford wasn't justified in using the deadly force. So again, the burden doesn't just apply to the elements of second-degree murder. It applies to whether or not Mr. Radford was justified in using the deadly force. So where does that take us? In talking about justifiable use of deadly force, as we said, if Mr. Radford was subject to imminent death or great bodily harm, he would be justified in using deadly force, or if the imminent commission of a felony, in this case felony battery. Well, let's talk about A. Imminent death or great bodily harm. We know that it was a planned attack by Mr. Lay. Detective Herrick had to admit that but for me finding buried in a cell phone extraction that was conducted in April of 2024, we would not be privy to some of the last words that Mr. Lay ever sent to somebody else. He told Sue Jones exactly what he planned to do. Detective Herrick also had to admit that and again, we have to separate how we feel about someone being an asshole, or a jerk, or mean-spirited, or using slurs. We have to separate that. We have to remove those layers of the onions and view this case as it pertains to the elements of the crime. But Mr. Lay, and Detective Herrick admitted this, one of the few things he admitted, because he didn't want to take responsibility or admit to a lie, he admitted that if somebody is blocking your path, no matter how inappropriate that would be, is not a crime. It is wrong, socially, societally. It's mean, you're a jerk, you're an asshole, but it's not a crime. And he went further when I pressed that if he was standing in a park and witnessed somebody blocking somebody's path, that it wouldn't be a crime. He wouldn't have probable cause to arrest. But that if the person whose path was being blocked decided to punch, hit, or tackle the individual blocking their path, that he would have probable cause to arrest for a crime. So, Mr. Diaz harped on the word if. And in trying to argue that it was a qualified threat or plan, he said that it says if. It says if this, then that. Well, he told Sue Jones, now mind you, that text directly conflicts with the type of person that all of the civilian witnesses said Mr. Lay was. But he told Sue Jones 18 hours before Mr. Radford called 911 to say that he was attacked, that if he blocks my path again, I'm going to attack him. Mr. Lay hit Mr. Radford over the head with his mug and tackled him to the ground. We know that Mr. Lay is 50 pounds heavier than Mr. Radford, is taller than Mr. Radford, and is 13 years Mr. Radford's junior. We also know that Mr. Lay was intimately aware, thankfully for the text message that I found, not the detective, that he was intimately familiar with the health issues that Mr. Radford suffered. He's weak and feeble. And a majority of his friends acknowledged that they knew too that Mr. Radford had significant health issues. Mr. Radford was, quote, direct quote from the interview, surprised how fucking strong he was, and quote, I heard a loud bang. There's a bright flash of light, and the next thing I know, I'm on my elbows and he's on top of me, rocking back and forth trying to dodge his moves. Now ask yourself about the evidence the state presented you. And we'll talk about what the state didn't present you. But they presented you with photographs of Mr. Radford with injuries to his face, which would be consistent with, and I submit to you as we look at these injuries, and for the record, I'm showing the jury what's been marked as exhibit, State's Exhibit 12A through H. Look at the bridge of his nose. There's no other reasonable explanation as to how you get that injury unless somebody hits your glasses in just the right way to dig into the bridge of your nose and fall off into the dirt. So again, consistent. Now, keep in mind, I am going to be consistently submitting to you that this is a clear case of self-defense. But just like Mr. Diaz told you, you don't all have to agree. If you're saying to yourself, I don't know who started it, I don't know, because the state of Florida has not proven to you what actually happened, it's not guilty. It's reasonable doubt. But it is absolutely reasonable that Mr. Radford was attacked. And what did he do? He called 911 immediately. Continuing with imminent death or great bodily harm. Now this is from the first interview. And we're going to talk about reasonable explanations as to why additional information would come out over time. But again, I just needed him to stop beating me. Now, I want you to ask yourselves, why is Mr. Diaz, who carries the burden, taking specific quotes out of context, quotes here, quotes there, what is fear? But when you watch and you assess and you digest every piece of evidence in its totality, not one piece of a 1,000-piece puzzle here, and one piece over there, and one piece over there, but you go through the evidence and lack that the state presented you throughout this trial, the 911 call, the first interview, the second interview, the third interview, the jail call, the sworn testimony, and you weigh and consider that together, contextually, not cherry picking, we know that Mr. Radford's story was consistent, that he was attacked and that he defended himself. But these quotes are from the first interview. I just needed him to stop beating me. What does that mean? I needed it to stop. I was fucking helpless. Well, Sounds like fear to me. It sounds like somebody that thinks that they have no other choice. I couldn't fight him off. No other choice. I couldn't stop him. Again, not cherry picking, not taking things out of context. These are from the first interview with Detective Harrop. Mind you, hours after a traumatic event. Hours after he's hit over the head with a steel mug. Again, the state has given you no reasonable reason to not believe Mr. Radford's story, or in any way to show you that what he's telling the detective in the immediate aftermath of being attacked, hit over the head with this mug, to the point where it cuts the glasses into the bridge of his nose. And you can see throughout you can hear through the 911 call, you can see in that interview, hurting. You can see in that walkthrough that he's getting progressively worse. My neck's starting to hurt really bad. I counted 5 or 6 times. He's constantly grabbing his neck. Now, as Ms. Bailey told you, either Mr. Radford, over the course of the last 10 months with the testimony and the statements and the interviews with the detectives, deserves an Oscar for having the foresight to plan in some capacity that one day I'm going to be alone with Mr. Lay and I'm going to antagonize him to the point where he attacks me, and then I can act in self-defense. And then I'm going to call 911, and I'm going to say just enough of the right things to make it look like I was defending myself. And then, hopefully there's no surveillance that captures what happens. Mind you, one of the first things Mr. Radford does when Detective Hoffman, or Deputy Sheriff Hoffman, shows up, and ask yourselves what makes more sense, right? Deputy Sheriff Hoffman arrives on scene prior to administering life-saving efforts to Mr. Lay. And this was admitted to by Detective Harrop, who reviewed body cams, Deputy Hoffman himself. He points to the sign at the park. For the record, this is State's Exhibit 2. Notice, there's a camera. And Detective Nix testified she saw it. Now, who that just murdered somebody in cold blood or started a fight, the first thing they say when a deputy arrives, there's a camera, get it, it'll show what happened. The only reasonable, rational, and logical explanation to that is that Mr. Radford was telling the truth. Because the alternative to that is that he knows the gig is up, or he somehow knows that those cameras aren't working. And again, that would be the state of Florida asking you to imagine or speculate or force yourself to believe that he somehow planned all of this out and was able to successfully say what he needed to say to establish that he acted in self-defense. And then the detective asks him, at some point you did pull it. I put in parentheses the gun. That's not in the interview, so I don't want you to think that that was said. Quote, I had to. This guy's going to fuck me up. Now, why is Mr. Diaz taking these things out of context? Well, it's because he wants you to not think logically, to not think rationally, and to not weigh the evidence in its entirety. Because he wants to cherry pick, where it's like faggot and gay. Because he wants you to act emotionally, which the law tells you you cannot do. And that is why he started his opening statement with those words. Offensive, yes. Wrong, absolutely, to say. But they do not make a killer, and they do not make a criminal. This is a man who is sitting in a room. Now, and again, in the interest of truth, let's look at some of the things that were asked of Detective Harrop. Mr. Diaz asked Detective Harrop on direct examination, did he ever say to you that his head hurt really bad? Detective Harrop, no. And then when I get up on cross-examination, I said, time out. Now, mind you, Detective Harrop told you he reviewed all the interviews, and that's why his testimony changed, from the previous hearing. But we saw Mr. Radford tell Detective Mullins 30 seconds before Mr. Harrop walked in the room, my head really hurts. She's like, well, I don't see anything, but there very well could be injuries underneath. That's normal. Again, misleading, out of context, from the entity, the state of Florida, that has the burden of proof. And the last quote is not from the first interview. The last quote is from the transcript that was read into the record. And it said, and Mr. Radford testified in that transcript, one of the things, among others, I put that on the slide, is I'm going to cave your head. Now, keep in mind, the first 5 or 6 quotes are all from an hour or two after the event. He being Mr. Radford, everything we as a society would ask somebody to do if they ever find themselves in the difficult, traumatic, and arguably one of the most horrific situations you could find yourself in. To take another human life to save your own. I couldn't fathom, nor would I ever imagine putting myself in Mr. Radford's shoes. But what I can tell you is that everything you saw on that interview, in that first interview, makes sense. Somebody that possibly has a concussion, being as honest and forthcoming as they can. Now keep in mind, he's not a police officer. He's not a lawyer. He's not a prosecutor. He's not a defense attorney. He's not trained in the ways of an investigation. So, he's answering the questions asked of him, but the fact that he doesn't volunteer information doesn't make him deceptive. Again, another leap, another request by the state of Florida for you to imagine or speculate. B. The second way it would be justifiable use of deadly force is if Mr. Radford is defending himself from the imminent commission of a felony battery. When someone actually and intentionally touches or strikes you against your will, causing great bodily harm, permanent disability, or permanent disfigurement. Now remember, it's the commission of. Mr. Radford has no burden here. The state does. But Mr. Radford didn't have to actually suffer great bodily harm to justify the use of deadly force. He just had to believe that he was going to, and or that he was preventing the imminent commission or the ongoing commission of this felony battery. He had been tackled by a much larger, stronger man. He was being beaten without the ability to stop it. Remember back to the quotes on the last slide. He was helpless. He suffered visible lacerations. Now, the definition of great bodily harm is given to you by the court, and it's right at the beginning of the jury instructions. I think it's the 3rd page. And it says, great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Well, we know what injuries he did suffer, and those are certainly beyond mere bruises. I submit to you he probably had a concussion. We know that he had neck issues. We could see that on the video. He wasn't faking that. We'll come back to this. So, reasonable doubt. And this isn't the entire definition, but most importantly, at this point, we're going to focus on conflicts in the evidence, and a lack of evidence. Now, Mr. Diaz stood up before you this morning and gave you a rendition and recount of the 1932 Game 3 of the World Series with Babe Ruth and the called shot. Well, there are 2 sides to every story, and I want you to frame Mr. Diaz's analogy about the called shot as we continue our discussion, and view that analogy in the light of Mr. Lay's past. Because one could submit that Mr. Lay called his shot. And again, while we know that Mr. Radford acted in self-defense, if you're sitting there, as I imagine you are, and saying to yourself, I don't know, because the state hasn't proven it, it's not good. It's going to be hard to read because it changed the font, but I'll do my best here. The evidence, and this is not an exhaustive list by any stretch of the imagination, but we have Mr. Radford having injuries consistent with being attacked, cuts on the bridge of his nose, consistent with being struck in the face, causing his glasses to dig in. The 911 call.
February 2, 2000.
Hello, 911.
I can't. Hang on. Hello?
Hello, no.
And I have a little note under this. I want you to pay close attention to my words, the genuine emotion and trauma, and this is something Ms. Bailey asked you to pay attention to throughout the trial, but the genuine emotion and trauma in his voice. Now, keep in mind, there's no time for reflection. There's no evidence to support that Mr. Radford did not call 911 within seconds or minutes of this incident happening. So there's no time for reflection here, and I want you to pay very close attention to every word. His responses to rescue, and his responses when they transfer him to the fire department.
Do you need police, fire, or medical?
Yeah, please. I just had to shoot somebody at West Dog Park.
Can you repeat that, sir?
West Dog Park. I was just attacked, and I had to defend myself. I had to shoot somebody.
Sir, what is the address that you are at?
It's Occidental Road. West Dog Park.
And do you have a weapon on you, sir?
I do have a weapon, and I'm unloading it, and it's on the table. I think he might be dead.
And about how long does this occur?
Minutes. I called as soon as I could dial the number.
And you said you're putting it on the table, so are you in a house?
No, I'm at a dog park. Dog park.
And who did you shoot?
This guy attacked me.
Do you have a man what's going on?
Yeah, I've been having trouble with this guy for months and months and months. I'll explain to the police when I get there. Oh my God.
And you are still outside that dog park? What are you wearing so that deputies can see you?
I'm sitting at the table in a camouflage jacket and jeans. Oh my God.
Jacket and jeans?
Yeah.
And where's the victim? Where is that guy?
He's just lying in the park.
You said he's in the park? Where in the park?
He's just lying in the park, man. Oh, God.
What is your name, sir?
Gerald. G-E-R-L-D.
And the person you shot, what is he wearing?
Shorts and a jacket. Oh my God, I think he's dead.
What color shorts, sir?
Gray, brown is good. Oh man.
She got anything? And last I recall, you said you were by a table. Are you still at that table, sir?
Yeah, I'm right here.
And is the weapon still on that table?
Yes, there is.
And you said you unloaded the weapon?
Yeah. Oh,
And it's that table you're sitting at, correct?
yes.
And how many times did you shoot him, sir?
One.
And where was he shot at?
I don't know. He grabbed hold of me and I was back on the ground. I was scuffling around in the ground. I managed to grab him. He hit me in the face with his fucking cup.
The unknown restaurant window shot one. Ma'am.
Alright, sir, and I just want to confirm, you're still at that table, correct?
I'm in the area of the table. The gun's on the table underneath my hat.
And when you say you're in the area of the table, where exactly are you?
Look, you walk in the gate and there's a table. You walk in the gate of the dog park, there's a table just to the right, under a gazebo. I'm under the gazebo.
Okay.
She's about 25 yards away.
You said he's about 25 yards away from you?
Yeah. I had to shoot him. He attacked me. He attacked me. I had to shoot him.
Hello there, sir.
Yeah,
I'm going to go ahead and get you over to the fire rescue. Please do not hang up.
I won't.
Hillsborough County Fire Rescue, what is the address of the emergency?
It's an Oxford Road, West Village, West Park, Dog Park. I see a police car coming now.
Okay, is this somebody was shot?
Yeah.
Okay. Are you the victim or are you with the patient?
No, I'm the no, the person said I have to do it.
I'm sorry, I couldn't understand what you said.
I'm the guy who has to do it.
Oh, okay. So you're calling 911 for the person that was shot?
Yes.
Okay. Yeah. You see the police officer? Can you flag them down?
Thank you.
I'll let you go talk to them.
Thank you.
You're welcome.
That's a lot to digest in there. I don't think anybody would disagree that that call is almost immediate after Mr. Radford has to defend himself. He's hyperventilating at times. He's clearly emotional. He says in just an excruciatingly painful voice things like, "I'm so sorry. I'm the guy who had to do it," fighting off tears. Consistent. And so that's step one. That's one of the things as a society we want somebody to do, because the alternative is somebody, and I think it would be a reasonable leap to take, and I don't have a burden, the defense has no burden. But if somebody is going to murder somebody, or wants to kill them, and selects them because they're gay, I think there's ways they might go about that don't involve calling 911, subjecting themselves to voluntary interviews, seeking victim advocates from the sheriff's office. "Oh, hey, Detective Harrop, you want to talk again?" "Yeah, absolutely." Answering the questions. And I certainly submit to you that trying to time a situation where only the two of you are at a dog park and you get them to fight you just so that you could shoot them and then go through all of that, that's not reasonable. But what is reasonable is what you heard on that 911 call. Every word of it is reasonable and consistent with what he told Detective Harrop within an hour or two of that. He exhibited all the genuine classic signs of both a head injury and trauma. Now, and again, it's not my burden to prove anything, but there's certain things that I observed. There's a dent in this mug. Whether or not that dent was there previously or caused when it went broadside with the glasses on on Mr. Radford's face, I don't know. But again, evidence. And if you don't know, it's not guilty. Emotional wreck on scene with Deputy Hoffman and Deputy Lowe. Now, on direct examination of Detective Herring. Mr. Diaz was pausing the video, saying, hey, are you about to ask him this? Or, is he crying again? Now he's not crying, right? Again, cherry picking, out of context. But when you view it in its entirety, and believe me, Mr. Diaz is right, we're going to spend a lot of time on Detective Herring. But before we get to that, Detective Nix. To her credit, she was candid with things she was obviously uncomfortable about answering, specifically as it pertained to that surveillance footage. But when we talked about trauma, she told you, candidly and in no uncertain terms, that throughout her career as a detective, she has seen everybody from no reaction to extreme reactions and everything in between. And that a roller coaster of emotions would absolutely fit and be normal with somebody that went through a traumatic event. Notwithstanding a significant head injury. So we have Deputy Sheriff Hoffman telling you that at the vehicle that Mr. Radford was an emotional roller coaster. He was crying at times, he wasn't at other times. We see in that interview uncontrollable sobbing and then completely normal. Because an hour and a half before that, he was smashed in the face. He was hammer-fisted. He thought he was going to die. He was fucking helpless. I just wanted it to stop. I couldn't believe how strong he was. And the unfathomable situation and decision that he had to make. And what did he do? And what did his testimony in the transcript that was read into the record tell you he did? He pulled his weapon. A struggle ensued over that weapon. Now Mr. Legg, who has attacked him, is trying to turn the gun on him. And they're fighting, and they're struggling. And ultimately, with a rush of adrenaline, he lunges and one bang hits Mr. I think it was right. Incredibly tragic, sad. But those words that you heard on the 911 call are genuine sadness and trauma. Deputy Hoffman told you that he couldn't remember his own name. Had to get it from his driver's license. Now I know on the 911 call he gets it out, but when we're talking about trauma and we're talking about head injuries, I mean, is that something where he's like, oh, this will go real good? This will make him think that this was self-defense. I'm going to forget my name and they're going to have to pull it out of my... No, the man was traumatized. He was distraught. He was despondent. He was in shock over the fact that he had to defend himself and take a human life. We've already talked about those quotes. He's nursing his injuries in both the interview and the walkthrough. Admissions from state witnesses. Mr. Legg making a prior threat. I guess we were going to come to blows. Mr. Legg would intentionally try to rile up Mr. Radford. And admittedly, they said that that was a two-way street. And ask yourselves, and we'll circle back to this again in a little bit, but ask yourselves this question. For some witnesses said a year or two because that's as long as they knew them. Other witnesses knew Mr. Legg and Mr. Radford for up to 6 years. For 6 years, no physicality, none. Hateful speech, riling each other up, getting under each other's skin. 6 years. And 18 hours after Mr. Legg says in that text message to Sue Jones, if he blocks my path again, I'll try to tackle him. He's older than he looks. He's weak and feeble. He doesn't really intimidate me. This weekend should be drama. Now, we could interpret that last line in a multitude of ways. I submit to you that it was going to be drama because, in Mr. Legg's mind, he was going to fight. He was sick of it. But you know what? Being a jerk, being an asshole, being a homophobe. And now, mind you, we're talking 6 years of back and forth between the two of them. Now, I know the civilian witnesses, and some of them were very candid with you. I love Mr. Lay. I would do anything for him. I want to see that man convicted, which we'll talk about bias of witnesses, right? Do they have an interest in how the case should be decided? That's something that the law tells you can take into account. Well, of course, I submit to you, all of Mr. Lay's friends have an interest in how this case should be decided, but some of them were more candid than others. But some of them told you. I did multiple interviews. I was calling the media. I was calling the sheriff's office. Arrest this man. Six years, no violence. And I asked Detective Harrop, do you think it's a coincidence? And, he had to get hard. I submit to you, it's absolutely not a coincidence that 18 hours after Mr. Lay sent that text message, Mr. Radford is on the phone with 911 saying he attacked me. Now, whether or not Mr. Radford blocked his path, which is not something he's admitted to, or Mr. Lay just attacked him, doesn't really make a difference. Now, I know Mr. Diaz told you that you can't start it, but the law requires that if you commit an assault or battery, meaning you have to actually be committing a crime, not standing in front of somebody, as Detective Harrop admitted is not a crime. But again, state of Florida's burden, not the defense's burden. If you're speculating and imagining and unsure, which I submit to you, you might be, or you believe it's self-defense, but if you're doing those things, it is reasonable doubt. Mixture of DNA on the gun.
Friday.
Here's the text message. And then he followed it up with, he's eat up with bursitis. I think he wants me to beat him in some weird, crazy sex I don't know. Thank goodness that I found this. And how embarrassing. And we're going to go into Detective Harrop's very soon, Detective Harrop's testimony. But how embarrassing for a lead detective, whatever that means to Detective Harrop, to not to make any efforts. He told you I looked at some text messages. Get out of here. That is a flat out lie. Because he told you how that software works when I pressed him on it. It's very easy to filter by item, text, email, call log, and you can specify a date range. Well, where better to start for a lead detective investigating a homicide once he gets that extraction? Because remember, I said, well, did you get actual evidence after that first week? Expecting and hoping that he would admit, no real substantive evidence. And he said to you, because I knew they let the surveillance video disappear because they didn't care about it, whether this Detective Harrop thought it was self-defense or not, he didn't care. But he gets this extraction back. He clicks text messages. He goes to February 1st. Hours, less than 24 hours before, and he goes, oh, that's not good for a homicide case, because I have Mr. Lay, who again, and I please ask you to not take my holding the state of Florida to their burden and defending my client as in any way disrespecting the tragic loss of life, because I cannot stress enough how tragic this is for us as a society for something like this to happen. But Mr. Radford is not guilty of murder in any way, shape, or form, or a hate crime. But my goodness, for me to have to find this 8 or 9 months after it was given to the state of Florida and after it was given to the detective, to never be presented, to potentially have never been found, because he couldn't be bothered to do his job. Again, the state's burden, and Detective Harrop is part of the state. He's weak and feeble. Conflicts in the evidence. Some civilian witnesses say Mr. Lay did not try to rile up Mr. Radford. He would never do that. He would never make a threat. He's peaceful. He's a pacifist. Others said he absolutely did. I think it was Mr. Darlington. There was one other witness. I can't remember if it was Mr. Miller, but there were at least 2, by my recollection, that said, yeah, I mean, they both would get under each other's skin. 6 years worth of that. No physicality. Never Mr. Radford because he's gay. No. He holds personal beliefs that are disagreeable to some or a lot of people. But for 6 years, there was never any physical violence. Some witnesses say Mr. Lay would never and never did threaten Mr. Radford, while others say Mr. Lay did tell Mr. Radford that they were going to come to blows. Again, interpret that how you will. Witnesses describe Mr. Lay as a pacifist. Mr. Lay's text says otherwise. Mr. Radford's testimony says otherwise. The 911 call says otherwise. The injuries to Mr. Radford's face say otherwise. The state's witnesses say otherwise. Mr. Radford told Detective Harrop that Mr. Lay threatened him. I've done it before. I'll cave your head. Mr. Radford's genuine, consistent, traumatic reactions on that 911 call, in that interview room, and in the walkthrough, versus, again, the state's side of the story, two sides to every story or theory, that he's this cold-blooded killer. That no matter what, I'm going to finally get him because he's gay. And that he's trying to pull off the acting job of the century. The victim specialist and advocate that was provided to Mr. Radford by the law enforcement detective investigating. How a lead detective should handle an investigation. Let's talk about that for a second. I pressed Detective Harrop on a lot of things. I think as a society and as citizens of Hillsborough County, citizens of the state of Florida should be absolutely appalled, horrified, and disgusted by the investigation that Detective Harrop conducted in this case. It is unconscionable that he would let that surveillance footage get erased. And then, in his efforts to hem and haw when I'm questioning him, is even more insulting. Because when the state was talking to Detective Harrop, smooth sailing. One would call it a well-choreographed routine. But when I got up and asked him some rather difficult questions, well, forgot his steps. And you could see from his body language and his answers that he wasn't being truthful. And that he refused to admit his failures in this investigation. In fact, he went so far to blame the rest of his agency. How many times do you recall him saying, "That wasn't my task"? Are you kidding me? We have an individual who's dead. You are the lead detective, homicide detective. Now, he told us he'd only been a homicide detective for a year, but that he'd been in a unit that investigated individuals that overdosed for 4 months before that. But clearly he was not cut out for the job. Because every step of the way he screwed up that investigation. And every time I pressed him on, why didn't you prioritize that video surveillance? That wasn't my task. And I understand that Mr. Diaz discussed they did the laser and he went and looked at it. Let's talk about that for a second, right? I submit to you that is a cover-up, an intentional cover-up for his failures. Because he knew he screwed up. How can I fix this? I know how. I'm going to go get a laser measurement, probably too far. And then I'm going to claim, and I submit to you that this is a flat-out lie. That I watched the live feed and the people were super. And then I said to him, well, Detective Harrop, you were trained in the writing of police reports, were you not? Yes. And you were taught that important information that happens during the conducting of your investigation needs to be put in those reports. Yes. Surely you put that you viewed the surveillance live feed to see what could and could not have been seen in your report. I mean, come on. And then when pressed on his conversations with the digital forensic analyst, about the video surveillance system and, you know, how far it went back and the digital forensics extraction, he admitted that as the lead detective, he had no conversations with them about the substance of those items. Now ask yourself, what? Hey, is there any way to recover this? How far back does it go? Well, then when I told him, well, it goes back to February 19th, one day after you finally decided to start looking for this video. I don't know. I didn't look into that. Absolutely disgusting. And again, whose burden is it? It's not Mr. Radford's burden. Mr. Diaz's burden. And that is a colossal hole and failure in the state's case. And the audacity of Mr. Diaz to stand before you and say, we don't know what it would have shown, is insulting to the standard and the law that the judge has read to you. Because it is their burden to tell you, to prove to you, so that you know, not just possibly, not just to imagine, but beyond and to the exclusion of all reasonable doubt. Mr. Radford's first words to Deputy Hoffman, or one of his first words, is, there's a camera. It will show it. Why would he say that? Because he acted in self-defense. Because Mr. Lay attacked him. And I will tell you, Detective Herrick believed that this was self-defense. And that may be an explanation as to why he dragged his feet. He didn't think this was going to go anywhere. Mr. Radford had injuries on his face. But then when the political pressure ramped up and the sheriff's office is communicating with the state attorney's office behind the scenes, and we got to do something about this political pressure, or the public outcry, he realized he screwed up. And so he tried to start making up for it. It was too little too late. They lost evidence that would have exonerated my client. But Mr. Diaz telling you we don't know what would have shown is reasonable doubt. That is a lack of evidence, and that is a failure on the state of Florida and their proof in this case. And to convict Mr. Radford of a crime when a video would have existed that corroborates everything you heard on that 911 call, the genuine emotion, the genuine terror, the genuine sadness. I mean, you could hear his voice cracking. I had to do it. And maybe the people were a little smaller because it was 200-something feet away. Well, guess what it would have shown? It would have corroborated that Mr. Radford got to the park first. And that allegedly, 24 hours after Mr. Lay's life was threatened, you're going to die, you're going to die. Now, we'll see this on another slide, but I submit to you, as we're going forward, think to yourself, I submit that it's very likely that Mr. Lay was setting up an alibi for himself for attacking Mr. Lay. There's no evidence presented by the state over the 6 years that you heard of all of this egregious behavior from Mr. Radford. He's verbally aggressive. He's homophobic. Not one individual in the year 2024 thought to record a video of it, record his behavior, ever felt there was a genuine threat to Mr. Lay's life to where they needed to involve law enforcement. And we know that Mr. Lay is lying on that video because he says the police told me to do this. And when I asked Detective Herrick about that, he said there is no record of Mr. Lay ever calling a non-emergency or emergency line to talk to law enforcement. And Detective Nix, when I asked her, said, hey, hypothetically, you're the lead detective on a homicide case. Because remember, she told you in this case, she was the crime scene detective that was assisting the lead detective. And there's video surveillance. And again, we have the benefit of hindsight of knowing that the park surveillance wasn't working. Mr. Radford didn't know that, right? For all intents and purposes, he believed it was, and then it would exonerate. But Mr. Radford didn't know there was a camera across the street. But we got out through questioning that officers canvassed the neighborhood on day one. Detective Herrick compiled that entire case packet, clearly didn't read it, and sent it off to the state attorney's office. And in that case packet, one of those officers acknowledged there was a video camera on one of the houses. Now, I tried to press him, well, aren't you observing these things? You're the lead detective. You're reading through these things. And he fought me every step of the way Weighing the evidence. Does a witness have an interest in the way the case is decided? Yeah, he does. Was he honest and straightforward in answering questions? Absolutely not. He fought me every step of the way. He forgot his steps. He was embarrassed that he didn't do his job. But Detective Nix told you, and all the credit to her, and I said it to her during the questioning. I said, look, I know I'm putting you in a difficult spot because she's essentially testifying that her colleague did a terrible job. How would you go the first day, the second day, or the third day? Would you wait 18 days? Clear as day that she did not agree with waiting 18 days to get video surveillance. And we've already touched on Mr. Lay claiming that the police told him to record the video blog. Lack of evidence. We've touched on some of this, but the negligent, ineffective, and I submit to you, criminally negligent investigation by Detective Harrop. Law enforcement knew on day one there was camera footage. Detective Harrop waited till, by his testimony, February 20th, 18 days after the shooting, as the lead detective, because it wasn't his task, to actually try to get that surveillance footage. There is not an adjective that does justice to how upsetting and appalling that fact is. No follow-ups on the surveillance till February 20th. No sense of urgency. And you can't script these things. Because when I was talking to Dr. Diaz, and I said, hey, now the state got up here with the skeletons, and are this possible? Is that possible? Is this possible? She said, yeah, it's possible. And then when I asked her, because candidly, the only thing Dr. Diaz can tell you is who impact. She admitted, she was honest, that she cannot tell you the orientation of the bodies. She agreed that in a physical, organic, violent struggle, that bodies can be moved around if somebody's grabbing a gun. All of that is possible. She acknowledged that the defense's theory is equally as possible as the state's theory. But on her own, I said, what type of evidence would help you determine body position? And I don't know if you recall, but I'm going to remind you. She said a video. A video. Efforts to cover up his mistakes. I submit to you, there is no doubt that these last minute, I'm going to finally apply for a search warrant. I'm going to start calling Eduardo. I'm going to do this laser measurement to show, oh, it's kind of far away. And I know I didn't put it in my report, but I'm going to tell the jury on the stand that I looked at the camera and you really couldn't see that well. That is a cover-up of his colossal failure. There is no other way to interpret that. He didn't review or discuss any of the evidence with the digital friend. I submit he didn't do anything. He didn't take any photos of Mr. Radford when he arrived on scene. He waited until after the interview. And then the state gets up here and shows you those photos and says, oh, this means that there wasn't a scuffle. He had been in the back of a police car in handcuffs. He's taken out of that car. The jacket's taken off of him. Tossed in the trunk of another deputy's car. All of the dirt and evidence lost because it wasn't properly bagged. Then he's allowed to take off another layer after he's removed from the car. He's put in another car, driven to the station, sat in an interview room, given an opportunity to go to the bathroom, given water, wash his hands, put back in a patrol car, go back to the scene. Does a walkthrough. But right before that walkthrough, 3-4 hours later, Detective Harrop says that one of the crime scene analysts finally takes some photos of him. Improper evidence retention. Lack of evidence. No eyewitnesses. There has been nothing presented by the state of Florida. Physical evidence that contradicts Mr. Radford's story. He has the injuries. You heard the 911 call. He was honest and straightforward. He cooperated every step of the way. Candidly, there was no new evidence after February 14th, but for some reason, public pressure, I submit, they waited until March 8th to arrest him. That wasn't my task. Did you canvass the neighborhood yourself? That wasn't my task. Did you follow up with the surveillance on the first day? That wasn't my task. Well, you're the lead detective, are you not? What does lead mean? Well, I had a sergeant, he's in charge. I said, no. You go to Sarge and say, Sarge, all hands on deck. I have an individual that lost their life. I have another individual claiming self-defense. We must do everything in our power. Put a car outside of that house 24 hours a day until the resident comes in or out and says, hey, do you have cameras? Oh, you don't own the place? You're renting? Okay, who's the owner? 18 days. Not my task. Wasn't my task. You have a body cam. I wasn't wearing one. Lack of evidence. Blamed everyone else for his mistakes. Detective Nix candidly told you she would have been seeking out that surveillance on day one, and the medical examiner agreed that the defense's theories, when I proposed to her that if somebody's knees are on top of you, and I mean, recall the injuries to Mr. Lake's knees, perfectly consistent with what Mr. Radford said. And I thank the state for pointing out that there were some pebbles on the ground and mulch and sticks. But I mean, these are deep gouges in Mr. Lake's knees. While he is on top of Mr. Radford, throwing down fists for 15 to 20 seconds, although to Mr. Radford it felt like an eternity, the dirt is embedded in him because he's on top of him, wailing, knees grinding into the ground. Again, two sides to every story. I submit, again, that this was self-defense, and that the evidence supports that. But if you're sitting there saying, I genuinely don't know what happened, not guilty. Reasonable doubt. Weighing the evidence. These are some of the items we've talked about here already. So it's up to you. You, the jury, are charged with and given the power to determine what evidence is and is not reliable. You are the triers of fact, and Mr. Diaz is right. You, as instructed by the law, should use your common sense. When you walked into this courthouse and into this courtroom, you walked in with your common sense. And I implore you to use it when you go back into that jury room to deliberate. Because when you, after listening to all the testimony and all the evidence, listening to the state, try to put this puzzle together, missing, 1,000-piece puzzle, I submit to you, maybe missing half of the pieces, but it doesn't matter, missing pieces. This case is filled with reasonable doubt. They're asking you to imagine. They're asking you to speculate. They're asking you to overlook a completely botched investigation. They're asking you to not listen to your ears when you hear that 911 call, to the genuine emotion in Mr. Radford's voice. They're asking you to not listen to your ears to that first interview. They're asking you, no, they need you to act on emotion because of the offensive language used, because of Mr. Radford's behavior. But did the witness seem to have an opportunity to see and know the things about which the witness testified? Well, let's talk about some of those civilians. Almost every one of them said that, or at least some of them, but they weren't always there. Some of the witnesses said it was always Walt and Deck alone first, and then they would kind of trickle in. Some of the witnesses that did see Walt and Deck only saw them on the weekends. But ask yourselves, over 6 years, if these individuals... Now, again, it's not just a tragedy for Mr. Lay losing his life. It's not just a tragedy for the altered path of Mr. Radford's life. It's not just a tragedy for their families, but also their friends who consider them family. And I have no doubt that Ms. Wolfley and Mr. Gumbert and the Darlingtons have suffered greatly for losing their friends. No doubt about that. But they admit that they never genuinely felt like there was any risk or threat, because there wasn't. There was no physical violence. Now, did the witness seem to have an accurate memory? Well, Detective Harris did not. In fact, when talked about ever telling Mr. Radford if he thought this case was self-defense, he said unequivocally to you on that stand, No, never told him. That's simple. Remember prior hearing? Yes. You were under oath? Yes. You swore to tell the truth? Under oath? Yes. And I had him read it to refresh his memory, and he said, yep, nope. My answer is no. And so we read it into the record, and he agreed that he said it at that time, and we're going to talk about his explanation. How many occasions did you tell Mr. Radford that you thought it was self-defense? I don't know if I ever specifically made that statement. Now, first of all, we're talking about a lead detective in a homicide investigation. This is not, hey, did you guys talk about what you had for breakfast on one of the days you met up? We're talking about the lead detective uttering the words out of his mouth to a potential suspect. Hey man, I think this is self-defense. Under no circumstances would your answer ever be, I don't know. Unless you did, and you're embarrassed to say it under oath, knowing that your supervisors and the state attorney's office is going to hear that you genuinely believed it was self-defense. Are you sure about that? I'm not positive about that. Again, ask yourselves, is that something a lead detective would forget? He knew military time to the second when he was testifying. Now, of course, I had to pull things out of him that I needed him to admit in front of you. But he is not sure if he told Mr. Radford, hey man, it's a process here, I think this is self-defense. That is a flat-out lie. So it's possible, in fact, throughout the course of the 35 to 40 days before Mr. Radford was arrested, that you actually told Mr. Radford, I think this is self-defense. Answer, I don't know if I ever stated that to him. So here we are again, 3 times. I don't know. It's possible you did, though? Answer, I don't recall ever stating that to him. So now that I don't recall, are you sure? I'm not, sir. Fast forward a few months, and his answer is completely different. No, I never said that. How is that possible? Well, I went back and watched everybody else's footage. Well, I submit to you that's not true, because we know that he didn't realize that Detective Mullen was discussing a head injury with Mr. Radford. I submit to you that he knows that this answer is troubling. And that if he says that in front of you, the jury, you're going to be like, what? The lead detective in a homicide case thought this was self-defense? On top of the fact that he allowed the surveillance, and that's probably why he didn't seek it out. Because like, this is just going to go away. It's a self-defense shooting. The evidence is consistent with that. But that was before the pressure. Or pressure from his agency. It doesn't really matter. There is not a circumstance on earth where it is fathomable that a lead detective investigating the death of a human being would not remember if they told a potential suspect it was self-defense. There's not a circumstance where that is possible. And then he had the nerve to tell you that because he watched Deputy Hoffman's and Deputy Lowe's, now his testimony, I submit to you, is inconsistent on that as well, because he couldn't remember certain things from other people's videos, but that he watched every minute of everybody else's body cams and knows for sure, because he didn't say it on those, never could have said it. But then he had to admit that there are interactions to and from interview rooms. He interviewed Mr. Radford at his home. That body cams would capture all of that. But in a snippet of time, hey, Mr. Radford, how you doing? He's got the recorder going. Okay, thanks. Shuts it off. Making small talk. Hey, man, it's just a process. I know it's self-defense. I just got to do this. But we don't know what was on that. I submit to you we do, based on his answers from the previous hearing and the fact that he lied. Was the witness honest and straightforward in answering the attorney's questions? No. Detective Harris was not. Dr. Diaz was. That's possible. Somebody could be on top, go prone on top of them, on the ground, struggling over a firearm, and that, although something that I told you would be an awkward position, then becomes less awkward because their arm's being forced that way. And again, think to yourselves, this is a real-time, live struggle. Somebody on the ground. Things are moving chaotically. There's no static skeletons or just we're sitting here, okay, I'm going to pull my gun, I'm going to lift it up, that's kind of awkward. No. This is a real-time struggle. Mr. Radford lifts his hip up as he's kind of rocking back and forth, gets his gun, Mr. Lay grabs it. And you'll get to see it if you'd like to, but I asked the doctor, is this sight here, where it's sharp, could that have caused that abrasion on his finger? Yeah. Again, we're talking about things, it's not our burden to prove anything, but as we go through this together, there is no doubt that the state hasn't proved their case. Their case is filled with reasonable doubt because of the evidence itself, a conflict in the or conflicts in the evidence and lack of evidence. Did the witness's testimony agree with the other testimony and other evidence in the case? And did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the court? Detective Harrop did, several of the civilian witnesses did, but admittedly, the civilian witnesses, friends of Walt's, they all blame Mr. Radford for this, and while Mr. Radford was responsible for defending himself and regrettably having to take Mr. Lake's life, it was justified. It was justified. And we know that because of those statements on that 911 call and in that first interview. We've already discussed this about Detective Harrop. Was Detective Harrop honest and straightforward in answering my questions? No, he was not. Did he have an interest in how the case should be decided? I submit to you, absolutely. Did the witness's testimony agree with the other evidence in the case? No. He didn't put in his report that he watched that live feed because he made it up. Did he at some other time make a statement that is inconsistent? Yes. Timeline. Actually, I'm going to back up 1 second before we get to this. Forgive me. When Mr. Diaz was before you, he told you that the motive for Mr. Radford to kill Mr. Lay, besides being gay, was that Mr. Lay had the nerve to ask him for a beer. Okay? And candidly, that's not true and a stretch. First of all, this wasn't murder. Mr. Lay acted in self-defense. But the testimony that was read into the record No, go ahead, I can't wait to hear this. Answer, fine. He asked me to go out for a beer with him, and I said no. Question, you mean like he hit on you?
Sir, when you're reading, you're going to have to slow down a little bit.
Sorry. You mean like he hit on you? Answer, I said he asked me to go out for a beer with him, and I said no. Question, yeah, but I'm a straight male. There's a difference between me asking Mr. Futch, maybe me asking Miss Bailey. One might think if I ask Miss Bailey, would you like to go get a beer? It's because I'm making a sort of romantic advance towards her. Answer. Or maybe you just want to have a beer. Question. Sure. Maybe. But that's not the way you took it. You weren't really upset that he wanted to get a beer, right? You were upset a gay guy wanted to go get a beer. Answer. I told him that I'm straight and I'm married, and if I go out for a drink, it will be with my wife. Right. You said, I'm straight, I'm married. The thing that caused the dispute between you was the gay guy made an advance towards you, and you decided to say, no way. Answer. In your words. Yeah. Well, that's a question. Well, you know what's weird? It's not my words, because even Walt in the text message, he says he thinks you want him to fight with you over some weird sort of sex thing. Answer. That's his mind, not mine. So, Mr. Diaz can try to twist Mr. Radford's words again, and twist the evidence to fit his theory, his story. But the reality is that Mr. Lay told us what he was going to do. Mr. Diaz told you that Mr. Radford mentally and verbally selected the victim. There's no evidence that he selected Mr. Lay to kill. No. He used homophobic slurs? Yes. He was an asshole? Yes. He was a jerk? Yes. He did things that society looks down upon and frowns upon and is unacceptable? Yes, yes, yes. But there's no evidence that he murdered. There just isn't. Because the physical evidence can tell multiple stories in this case, reasonable, plausible theories that he acted in self-defense. None of the witnesses, Mr. Diaz said that he, being Mr. Radford, had a problem with them. And that's just not true. Several of them got up and told you that they got into words with him, that he was verbally aggressive towards them as well. But again, no violence for 6 years. When Mr. Diaz was talking about great bodily harm, he used the phrase, Mr. Radford didn't think he was going to be in a wheelchair for the rest of his life. That's not the law. That's not what the law says. If you go back there and the law tells you that unless somebody feels like they're going to be confined to a wheelchair for the rest of your life, color me surprised. But that's not the law. It says that it can't be trivial or slight, more than bruising. We know that he had more than that. And it's not what he suffered, it's what he thought. A reasonable person thought they were going to suffer. You heard his words on that 911 call. You heard the sadness, you heard the emotion, and you heard the trauma. Now, Mr. Diaz felt like it was going to be like an aha moment with the video walkthrough, and I didn't touch on this. And I don't know where that was going. He mentioned that Mr. Radford would have heard Mr. Lay coming with his dog. So he was lying in wait. Well, first and foremost, Mr. Radford goes to the dog park almost every day. And the witnesses said that he's usually the first one there, if not at the same time as those witnesses. Mr. Lay knows that. And ask yourselves, if Mr. Lay was truly threatened by that alibi video, I'm calling it an alibi video because that's what I believe it is. If he was really threatened, if somebody told him, somebody being Mr. Radford, somebody that people have testified, both of them had hated each other for years now. They didn't at one point. They were friends. And they were friends when Mr. Radford knew he was gay. So clearly, that wasn't a problem for Mr. Radford. The deterioration of that relationship that the evidence shows was because of things like politics and COVID and masks and vaccines. Liberal versus conservative. Because the civilian witnesses acknowledged we were cordial at one. Now, some said, some implied that they were better friends or just kind of acquaintances, but the evidence is that he knew he was gay before that relationship deteriorated, which doesn't comport with the state's story or theory that he hates him because he's gay. Well, he uses improper language. He grew up in a different time where that was part of the lexicon. Is it right to continue to use it? Nobody is saying that. But that doesn't make him a criminal, and it doesn't mean he committed murder. And it certainly doesn't mean he targeted Mr. Lay. But when we're listening to this video, as Mr. Diaz was trying to show us, like, oh, there's the picnic table, and he's lying in wait, and he would have heard his dog. Well, right when that's happening, an airplane at like 180 decibels is blasting overhead. So, again, we're speculating and imagining on Mr. Diaz's behalf. Maybe he hurt his dog. Maybe he was lying in wait. Again, no evidence of this. I mean, the state is asking you to imagine. No, they need you to imagine certain things. They need you to speculate. They need you to force yourself to put those puzzle pieces when you know they don't fit. Because they are lacking evidence. Evidence that would have exonerated my client. Evidence that was lost as a result of law enforcement's deficient investigation. Mind you, that everything you've heard from Mr. Radford in those interviews and 911 calls are consistent and make sense and are reasonable. Maybe Mr. Lay's dog wasn't barking that day because he had Mr. Gumpert's dog with him and they were playing. Again, I'm allowed to imagine and speculate because I don't carry a burden here. But there are other rational, reasonable explanations. There is no evidence that Mr. Radford was lying in wait. None. None whatsoever. Mr. Diaz asked you, or wants you to, look at the jury instruction about justifiable use of deadly force and specifically implies that because Mr. Radford used force or assault or a threat of force, that he had a duty to retreat. Again, you have paid close attention. Mr. Diaz is right. You've been taking thorough notes. You've been locked in, listening to every witness, watching every interview, listening to every 911 call. There's no evidence, actual eyewitness evidence, beyond the version of events we have from Mr. Radford, that Mr. Lay was attacked by Mr. Radford. Are there some abrasions on him, as testified by the doctor? Sure. But I think if you look at those two pictures, not I think, I know. For the record, this is State's Exhibit 20, 8 through N, showing the jury what has been marked as photo pay. And on side by side, State's Exhibit 12A. Who got the better of who? If Mr. Radford, lying in wait, attacked Mr. Lay with his mug so hard that, and again, these are the speculative, imaginary situations, I'm sorry if I'm blocking this a little bit, that the state is asking you to do. Again, in direct contradiction of the law and what the burden they carry. They're asking you to imagine. They're asking you to speculate. If he hit him over the head so hard with his mug that the handle broke off, is that the injuries you're going to see? Absolutely not. That doesn't make sense. Using your common sense, you know that's not true. Is it possible that Mr. Radford, when he was struck over his head and fell to the ground on his elbow, that a handle, mind you, when you look at the photos, is not screwed on? I don't know if you remember me asking, was it screwed or glued? You can clearly tell it's just like some type of glue, and it just snapped off. Reach after reach after reach, asking you to use your emotions to convict Mr. Radford of a crime they have not proven. Told you that he was not in fear of death, and that the defense will say that kick my ass means Maine. No. I will say, I was fucking helpless. I just wanted it to stop. I couldn't believe how strong he was. There's no other interpretation of I was helpless. Did he say the words, Detective Herrick, I was in fear of great bodily harm or death? No. But when you use the language that he used, it's abundantly clear that he was terrified of great bodily harm or death, or stopping the commission of a felony battery. Mr. Radford, or Mr. Diaz told you the only way John Walter Lay gets to speak is that selfie video. Also not true. Because we have his text sent after the selfie video. So here's the timeline. On January 30th at 10:19 p.m., Sue Jones texts Mr. Lay about Mr. Radford. Goes unresponded to until February 1st, 2024 at 7:58. On February 1st, 2024 at 7:58 in the morning, Mr. Lay records a selfie video. Now, mind you, 6 years of alleged super hyper-aggressive Mr. Radford, and, we were so scared of him, and he's just so dangerous. No calls to the police. No filming Mr. Radford's behavior. No request for the police to trespass him. Nothing. But Mr. Lay records a selfie video. You're going to die. You're going to die. He says it twice on that video. Doesn't call the police. Doesn't record Mr. Radford doing it. No evidence that it actually happened. He wasn't afraid. I submit to you that probably, maybe, isn't even true. I submit to you it's not. Because anybody that their life was threatened, ask yourself, the next day, would they get up? So you know what I'm going to do today? I know that guy that we're all afraid of, and remember back to the testimony of his friends. Walt withdrew himself from the situation. He did everything he could to stay away from Mr. Radford. He avoided him. He would sit at the other table. Is that consistent with what Mr. Lay did after recording that selfie video? What did he do? Let's forget the text messages for a second, because on February 2nd, in the morning, alone, knowing Mr. Radford is always at the dog park as one of the first people. The individual who allegedly threatened him with death, ×2 the day before, and has previously said horrible things to him, and previously verbally threatened him and blocked his path. What does he do? He goes to the dog park to confront him. Now, I'm telling you to confront him. The state wants you to believe that. Why should he have to stop going? He should have stayed home. No, I'm not saying he should have stayed home. I'm saying it's not true. Nobody in their right mind whose life was threatened, A, wouldn't call the police, and B, the next day would go to the park and be alone with that person. Nobody. Unless they're looking for a fight.
I'm sorry, I missed that.
Unless they were looking for a fight. So on February 1st, and again the font changed, I apologize, but at 1:11 p.m., Mr. Radford responds to Sue Jones. Hello, I'm at work. Our computers are down. I was able to get all his info from the morning crew. He's crazy. He doesn't have anywhere else to go. He doesn't really intimidate them. Now, ask yourselves, if hours before his life was threatened, either that's patently false and a lie, and he's creating an alibi for himself because he is sick of Mr. Radford's shit, as the witnesses said. And then he's like, I got an idea. I'm going to record this threat because I do want to fight him. I'm sick of it. I've told him we're going to come to blows, and here we are. Here we are. I'm not really he doesn't really intimidate me. But allegedly, hours before, he said, you're gonna die. I thought if he blocks my path again, and mind you, he's talking about the individual who told him he was going to die. I'll try to tackle him. He's really older than he looks. He's weak and feeble. I'll keep you informed. This weekend should be drama. There is no other way to interpret that. That Mr. Lay wanted and was prepared to attack Mr. Radford. And again, the physical evidence corroborates that. Mr. Radford's 911 call corroborates that. His interviews corroborate that. And the state of Florida would have you believe, would need you to believe, that because Mr. Radford didn't have diarrhea of the mouth, exactly how they would have done it. Remember, Detective Nix, there is no right or wrong way to react to trauma. Right? Everybody reacts differently. Detective Harrop admitted it too. One of the few things he admitted. Because Mr. Radford didn't say it the way Mr. Diaz wanted him to say it, in the order he wants to say it. Guilty. Lie. No. Absolutely not. He's eat up with bursitis. I think he wants me to beat him. Well, that's what Mr. Radford said happened. Now ask yourselves. And I asked the detective this. Well, I mean, that's a different thing. It's not the same. Different messages. Get out of here. That's laughable. It's insulting. Those things are diametrically opposed. A selfie video that you're keeping for your safety. Sharon told me to do this to protect myself. So that implies that he believes it. Implies. But we know he didn't because hours later he sends this message. Now ask yourself. There's only a few possibilities here. Either he made it up, or this is all true. Well, I submit to you that this message is all true. But either the video is made up, or Mr. Radford did it and he didn't believe it. But either way, we know what Mr. Lay. Because remember, Mr. Diaz told you that his voice is heard only through that selfie video. No. Because that selfie video is not the last of Mr. Lay's words. These are the last known recorded words that we're aware of right in front of you. 18 hours before Mr. Radford called 911, a call you listened to shortly ago. Mr. Lay says, now mind you, never physical violence between the two. I'm going to try to tackle him. He doesn't intimidate me. He's weak and feeble. He knows about his ailments. The witness testified he knew about his ailments. And then Mr. Radford is hysterical on 911. I didn't have a choice. I was helpless. Mr. Diaz told you I'd get up here and talk about Detective Herrick, and we have. And he told you he would like video. And I'm sure you would too. But guess what? We don't have it because of Detective Herrick. And that is a lack of evidence. You can find a reasonable doubt based on a lack of evidence. And there is no bigger lack than the investigation that the lead detective allegedly conducted in this case. He couldn't have seemed more disinterested. He couldn't have seemed more interested in kind of pawning off his responsibilities on everybody else. Well, that wasn't my task. So what? I don't believe for a second that the Hillsborough County Sheriff's Office would fragment a homicide investigation between 5, 6, 7 detectives that don't communicate with one another, that don't talk about the case. That makes no sense. You know, what do? They have a lead detective that all the information funnels to, who's in charge of the investigation. Go do this, go do that, I'm going to do this. Oh, there's a sign that I saw as I walked into the walkthrough of a camera at the park. That is priority number 1. There is no better evidence than video. None. Absolutely none. And he didn't care. So yeah, we were going to talk about Detective Herrick. For good reason. It's incredibly troubling that the state would acknowledge the lack, but then turn around and say, well, we don't know what would have been on it. Well, that's not Mr. Radford's problem. That's not Mr. Radford's job. That's Mr. Diaz's problem and Mr. Diaz's job. And that alone, I submit to you, should lead to reasonable doubt. Do not let the state tell you that Dr. Devers supports their theory over any other theory in any more capacity. Do not. Because you heard her testimony unequivocally. She cannot testify to the orientation of those bodies. All she can tell you is the bullet path. That's it. And in a real-time fight, she agreed that it would be just as feasible for a bullet path with a struggle over a firearm, if somebody's offset, that it was possible. She couldn't tell you anything without video or eyewitness testimony. Mr. Radford acted in self-defense. He was in reasonable fear. There was a struggle over the firearm, and he had to take Mr. Lay's life to save his own. Mr. Lay was conducting a forcible felony upon Mr. Radford, a felony battery. There is no credible, competent, substantial evidence that takes the state over the finish line to meet their burden in this case. There just isn't. There was discussion in Mr. Diaz's clothing about Mrs. Darlington saying, I want to kill him. And in a vacuum, without context, that doesn't sound good. It doesn't. But when we add context, like 6 years of a contentious relationship, could we say to ourselves, could have been a figure of speech, absolutely. But when we add context, like how we analyze what Mr. Lay's friend said when confronted with this text message. What if I told you that Mr. Lay, I think Ms. Wolfley, one of the first witnesses, he probably just joking. Maybe he was. It's a state first. I don't think he was joking. But I submit to you that when you are getting under each other's skin for years and years and years, when you have that individual, Mr. Lay, admitting to other state witnesses that he's doing it on purpose to rile up Mr. Radford, at some point, you may say something like, I want to kill him. That doesn't mean you did. Especially when the evidence isn't consistent and doesn't prove a homicide. It just doesn't. Especially when we have Mr. Lay's last words that he's going to tackle Mr. Radford. Especially when you use your common sense and you think about that 911 call. Truly think about it. Listen to those words. Listen to that emotion. When you watch that interview, when you watch that walkthrough, when you think about his cooperation, When you think about his injuries versus Mr. Lay's injuries, the entire picture, not a cherry-picked quote. Mr. Diaz told you that it was a called shot at Babe Ruth. Two sides to every story. I submit to you that Mr. Lay called the shot. Which is it? The evidence shows that Mr. Radford acted in self-defense. No doubt about that. But like I said, even if you don't believe that, after listening to all the testimony and listening to all the evidence, if you don't believe that it was self-defense, you're probably sitting there saying, I don't know what happened. That is reasonable doubt. That is not guilty. These are the quotes taken out of the text messages. This weekend should be drawn. In the most tragic of ways, it was. I am incredibly saddened that we find ourselves here. As is abundantly clear at this point, incredibly troubled by the presentation of the state's case when it comes to their burden of proof. Members of the jury, I appreciate your time and attention in this case. I ask you, when you go back into that jury room to deliberate, to take your common sense with you. I ask you to truly hold the state to their burden, to not act emotionally on the mean slurs or homophobic statements or the claimed aggressive behavior against Mr. Radford. Because remember, before you get to the enhancement, you have to find that Mr. Radford, in fact, committed murder or manslaughter. Because the enhancement says, if you find that Gerald Declan Radford committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that he, so remember, you have to find that person. I submit to you, there's no way, based on everything presented, two sides to every story. The evidence fits, that's reasonable doubt. But that he perceived, knew, or had reasonable ground to believe that of his sexual orientation. No dispute there. None at all. 2, intentionally selected John Walter Lay II because of that perception. There's just no evidence of that. None whatsoever. As it pertains to second-degree murder, the state has not established, first of all, that the use of deadly force wasn't justified. Their burden to prove to you beyond and to the exclusion of all reasonable doubt it wasn't justified. And we've gone over more reasons than we can count as to why. But he's not guilty of that. That the homicide was justifiable. That it was done while resisting the commission of a felony upon himself. That it was done to stop the imminent threat of great bodily harm or death. And he's not guilty of manslaughter because the killing was justified for the aforementioned reasons. So, when you go back and deliberate, and you weigh the evidence, and you hold the state accountable to their verdict, I ask you to return the only verdict supported by the facts, supported by the evidence, and supported by the law, not emotion. And I ask you to return a verdict on the verdict form of not guilty. Choice C. Thank you.
All right, we're going to take a quick comfort break before we conclude.
All rise.
All right, we are going to go over what we've heard so far, which is a lot. So we started out with the state closing, and while we do this, here, check this out. Let me pull up. What is that? Okay, let me pull up. Hold on a sec. I got some photos of the area, so we can kind of see what's going on here. All right, so here, all right, so there is Tampa International Airport is just to the south. So that's why there's so many, airplanes. I mean, literally it's like a few blocks away, right? So this kind of gives you a general idea of where it is. I've got a couple more. Let me pull up a couple more. So that's that one. This is a wider view. Right, so that's the Gulf there. You've got St. Pete, Clearwater to the west. Tampa's, what's that, southeast. And the dog park is, you can see a little bit. And then, Brett, you just asked the question, was there any other dog parks? To me, I'm not sure. I don't think so, right? So there's the dog park. There's that Egypt Lake Recreation Center to the east. And then there's this down here, this Al Lopez Field, kind of towards the southeast as well. So to me, I'm not seeing, to me, that looks like the only dog park in the area. Right? So I hope that helps you guys kind of place it. All right, so let's go through what we heard. So state closing. So he starts out with 1932, Game 3 of the World Series. Babe Ruth steps up to bat. Capri Law, you should like the analogy, right? He starts out with a baseball analogy. He looks to the outfield and he points to a spot. He smacks the hell out of the baseball. For months, Radford told us what he was going to do. Radford called the shot. Radford said ugly, hateful slurs over and over again. And it was Genovese, who he hadn't seen in years. Remember the Genovese yesterday? What was his name? William Genovese. Hadn't seen him in like 2 or 3 years. And he starts, kind of trying to find out, hey, what's going on with the dog park crew? Tell me the latest, yada, yada, yada. And then he gets to Mr. Lay, and all of a sudden Radford's demeanor changes and he starts, yelling, starting up with the slurs again. The 24 hours, Radford is telling Lay, you're going to die. That's from that video. Whatever your opinion is on gay people, that man had hate in his heart and he killed Lay because he was gay. That's what the state is saying. So second degree is the first charge, and then manslaughter is the lesser included offense, and then you have not guilty. So those are the 3 that they have to decide. I don't have to prove that it wasn't intentional. That would be first degree. He carried and he used. Did he possess a firearm? Yes. Did he discharge it? Yes. Did he kill someone? Yes. So we were wondering if he had it concealed or not. I think because he says during the struggle, he was able to twist over, even though his left arm was pinned to the ground. He was able to twist over, and he said he reached behind him, and so I don't think it was in a holster per se. I think it was concealed. I don't think it was out. So I put in the chat, I wish somebody on either side had asked the dog park crew, had you seen this weapon? Because that's kind of a big thing. If I was hanging out with some people at a dog park and I happened to see a gun, or since they were talking about a lot of hot topic issues, I'm sure gun control, because there were mass shootings in those 6 years that these guys were hanging out, I'm sure the topic of conversation came to, wow, maybe we should regulate guns. Maybe we should do this. Maybe we should do that. So I would think, A, you probably know that he's a Marine. B, you probably know his feelings on guns and people shooting each other. So I wish somebody had asked that dog park crew, did you know he had a gun? Because if they said, no, we never saw him carry a gun before, and then all of a sudden he's got a gun that day, that definitely proves intent to me. or if they're like, oh yeah, he always had a gun, we always saw it, wouldn't Mr. Lay be more concerned about starting a fight if he knew that this guy carried a gun? So that's where my mind is going. So I wish they had asked. I think that to me, this verdict could hinge on that. All right, let's carry on. Once he was asked out for a beer, it started to unravel. What's in his heart and mind? Is it fear or is it hate? So imminent death or great bodily harm. He needs to reasonably think he's going to die or get maimed, not possibly. He has to reasonably think that. So who started the fight? Be in a place he has a right to be and not committing an offense. So who started this fight? That's again, if Lay knew that Radford was carrying a gun, would he have really started this? I know I wouldn't. If I knew an ex-Marine was carrying a gun, I wouldn't start a fight with him. No way. So if he knew the dog would be barking, then he would know where Lay was. So again, that shows that intent because Follow the Dog was barking a lot. He would always say, "Oh, here comes that fucking effing guy. Here comes the dog. Here's Luna. I'm sorry. Follows barking. So he knew where Mr. Lay was. So let's see. Radford has all the hallmarks of a bully. Yeah, 100%. He can't claim self-defense unless he initially provoked it. So there you go. So you can't start a fight and then get your ass kicked or start to get your butt kicked and then all of a sudden pull a gun or a knife. I mean, that just changes the whole dynamic. You just can't do that. You can't pick a fight and then get your butt kicked and then pull a gun. Were you in fear? What's fear? I didn't want to get my ass kicked. Yeah, I thought he was going to kick my ass. Once I got blood on my face, I was kind of scared. The third interview, he starts to say he was in fear for his life, but after he saw Lay's video. So he's changing his story. Then they show the text messages from Lay. If he tried to block my path again, I'll try to tackle him. So it's an if-then. If he try to block my path again, then I'll try to tackle him. So Radford is the aggressor here. Radford is the one. Nobody said anything about Lay ever getting in Radford's way to block it. It was always Radford blocking Lay. It was always Radford blocking Lay. So Lay doesn't say anytime like, I'm going to break his nose, I'm going to pound his face, I'm going to break his legs. No, he just says, I'll try to tackle him. And the defense is going to point the blame at Detective Harrop. Yep, they sure did. If we had gotten the video, it would have proven Radford's innocence. Sure. Could have also proved he was guilty. If you don't believe in victim blaming of Detective Harrop, then it's the DA's fault because they railroaded Radford. He's the victim. Right. So if you don't go with the victim blaming because it was Lay's fault that he was there, then you blame Detective Harrop and his botched investigation, or then it's the DA's fault because political climate and everybody was clamoring for some kind of justice. Everyone's a bad guy except Radford. We see that all the time. Defense said in opening, it's a First Amendment issue. Everybody at the park was telling Radford, you can't call him that anymore. It's 2024. Just stop it. He didn't just say he said it to his face. So he didn't just call him, derogatory names. He said it, went right up to his face and said it. If the state is asking you to fill in the gaps, that's reasonable doubt. So the first poll we took was, did the state prove their case? And is Mr. Radford ... guilty, not guilty? 65% of you thought the state proved their case. 34% said not guilty, 65% said guilty. So then the defense came up, Mr. Futch. This weekend should be drama. That's what he starts out with. What happened is tragic. These are some of the last recorded words Mr. Lay ever shared with anyone. And he goes through the video. You don't have to find self-defense to make him not guilty. If I hadn't found the text messages, we wouldn't have seen them. We have to be able to separate someone being an a-hole and a jerk from somebody killing somebody. One of the few things Detective Harrop admitted to, that someone blocking your path is wrong, but not a crime. Yeah, I agree with that. Lay hit Radford with his mug and tackled him to the ground. Where do we have any evidence of that? That's just pure speculation, but I guess that's what you're allowed to do in your opening and closing. There's no evidence that he got hit with the mug. It's absolutely reasonable Radford was attacked. We know Radford was consistent with his testimony that he was attacked. I just needed him to stop beating me up. I was effing helpless. I couldn't fight him off. I couldn't stop him. These are all the things he said. He was hit over the bridge of his nose with this mug. That's not proven. There's really no evidence in that. The DNA didn't really prove that. They play the 911 call in which he says, I was just attacked and had to defend myself and shoot somebody. I do have a weapon and it's on the table. I think he might be dead. This guy attacked me. I've been having troubles with this guy for months and months. I've been having trouble with this guy for months and months. No, you're the one that has an issue with him. Not that you've been having trouble. You have an issue with this guy. He grabbed hold of me and we were rolling around the ground. He hit me in the face with his effing cup. I had to shoot him. He attacked me. You know, they would both rile each other up. So 18 hours after the text message, if he blocks my path again, I'll try to tackle him. So 6 years, this went on for 6 years, this back and forth. I think he wants me to beat him in some weird, crazy sex thing. I don't know. That's kind of weird. Harrop couldn't be bothered to do his job. Yeah, he was really, really going hard on Harrop. It was up to me to find the text message. Law enforcement, yeah, a completely botched investigation. And then he had the nerve to tell you that he watched every moment of the body camera, meaning Harrop. There's no evidence that Radford selected Lay to delete. There's no evidence that Radford selected Lay, other than call him all kinds of names in the book, well, specific to his sexual proclivity. But yeah, the mug handle was glued on and not screwed. 6 years of alleged, we're so scared of him, no calls to the police. That's low. That's a low blow. That's low. The video from Lay, he submits to you that the video from Mr. Lay, that it's not true what he said. So victim blaming. That, you know, he didn't say that. He said that. We know he said it, but he didn't really feel it. Nobody who feared for his life wouldn't go back to the park unless he was looking for a fight. That's like telling somebody... That's like telling a woman not to go into a bar with a short skirt on because she's looking to get. I mean, I just don't agree with. I hate. He's a good lawyer. I don't mind Mr. Futch as a lawyer, but I don't like some of his. I don't agree with that. All right, so 44 votes. What will the jury do? So we had, did the state prove their case? And then what will the jury do? 52% of you said guilty, 29% of you said not guilty, and 18% of you said hung. So now we come back. Well, let's see what you guys are saying first. Let me go back here. What are you guys talking about? Kathy Smith, his toxic masculinity was affected. Too much negative. Yeah, agreed. Squeegee's face palming. Well, you know, it's like that victim blaming, you know. Hate it. Completely with you on that one. Hey, Dwayne, how you doing? Lead detective's testimony was a joke. As an armchair juror, I would have to vote Mr. Radford's not guilty. I don't like his beard, but his beard is not on trial. Not guilty. Dwayne, you're funny. You're funny. If we end up hating the hater, does that make us haters too? Yeah. Of course. Trial Junkies United. Objection. I think Radford liked the defendant and didn't know how to handle those feelings. I would have to agree with that. Evil Queen says, my 15-year-old grandson was being hit on by a guy at school. He was very upset about that. He actually started watching Ben Shapiro to quote him. I've been hit on. I'm not going to lie. I've been hit on. I've gone to gay bars. You know, it's doesn't make me gay. Doesn't make me, you know, anything. It's just, I think when people are uncomfortable with it, they just have to examine that and look at it. You know, why are you uncomfortable with it? I'm not going to tell you what you think. I'm not going to say what you should do or feel, but just look at that. Like, why are you so angry about it? You know? Ken Rosenberg, I don't know if my opinion has really changed. From the jump, it seemed the defense was really comfortable with the juror and they catered to them at every possible with their juror, and they catered to them at every possible moment. Yeah, so yeah, absolutely. Gay bars are fun. Yeah, I go back to New York City because I spent 17 years there. I mean, I knew a lot of gay people. I played in a lesbian band. I played with a drummer who was gay. I played with women that were lesbians. I've played, I've been in many places that, it's New York City. I was running with the art crowd. That's just the way it was. So I knew who I was. OnlyFan, yeah, I straight up ask direct questions if I meet gay people. It's very refreshing. Kathy Smith, confident in who I am. Yeah, that is true. Yeah, it does. It really does boil down to, are you comfortable in your own skin? Therapist, I'm going to require many more words than that. I know you have awesome stories. Yes. OnlyFan, my male lead singer turned into female lead singer. There you go. Never had that. Never had a sex change. But Amanda's Waiting, the two lead, they were both singers. One was lead, then the other was kind of backup, and the other she played guitar. Yeah, they were in a relationship. And then they had a drummer come on. But then I was in another band called Buffalo Sky, and that drummer, he was gay. He was great. I loved him. He was fantastic. He passed away. He got HIV and he passed away. Child Junkies United, gay guys always want to be my friend. No issues here. Gordon, weren't you in the Village People? No. I'm old, Gordon, but I'm not that old. Nanar, I've been to a few gay bars, even a strip club or two. The strip club show was lame. My husband and I went with another couple. I have been dragged to strip clubs once, and it's just not my thing. I'm just like that makes me uncomfortable. That makes me more uncomfortable than going to a gay bar. I'm just not a fan of that. I just don't like the commercialization of people like that. That's where I do draw the line with that. Yes, even I have lines that I draw. Green Eye Cat, I agree. It's your own stuff to get so angry and triggered. Absolutely. Evil Queen, I love all my gay friends. I live in Atlanta. They know who to hit on and who not to. Yeah. So, all right, let's get back to the trial. Let's see, dog bark. Let's get back here. Let me just pull up the thumb real quick while I do some zooming. God Junkies United. Objection. If you start seeing YMCA, that song got ruined. I know. Not going to talk about that here, but I know. Baka, never have I ever been to a strip club. You're not missing anything. Capri Law, cannot imagine me in a strip club. Yeah, it's just not that made me uncomfortable. I was just like, no, not for me. Green Eyed Cat, I love going to gay bars. Went to New Year's for many years. So much fun, always good music. Yeah, and I lived in the East Village for many years, and it just was everywhere. Just the West Village was what was known as that was more centralized or whatever. A lot more gay people were there, but I hate to say gay people. A lot more people that were of that lifestyle lived there. So it just didn't bother me. I didn't care. All right, what's going on here? Judge talking. Let's see if we can zoom. A little bit more zooming. Okay. So next up is going to be the defense. Yeah, I'm sorry, state. State's coming up again. Trout Junkies United, you need a drag queen to teach you how to put on false lashes. I have the worst time putting them on. Dwayne says, my brother and Sharon's son take us to gay bars all the time. We have a ball. Queens know how to party and respect boundaries. That is true. All right, I keep wanting to find where they start talking again. Let's see. All right, here we go. Okay, here we go.
Mr. Diaz?
Thank you, Judge. If you wrote down any one thing I said, I hope it's the timestamp, 13 minutes and about 10 seconds under the recorded audio of the first interview of Gerald Declan.
Okay. So he comes walking the other way in and said something. And I said, fuck off. And we're like walking towards each other. And he just fucking, he said, get away from me or I'll kick your ass. I don't know what he said. I can't say what he said or I'll kick your ass. I said, what are you going to do?
So he comes walking the other way and he said something. That's Gerald Radford seeing the victim walking towards him. And I said, fuck off. Will you just... We're like walking towards each other. They're walking towards each other. And he just fucking... He said, get away from me or I'll kick your... And then he stutters. He stops. He catches himself. I don't know what he said. I can't say if he said, I'll kick your ass. I said, what are you going to do? That's Gerald Radford by the picket bench. It's Walter Lay coming in the park, walking towards each other. That's not Walter Lay ambushing Mr. Radford. That's not blindsiding him. That's Walter Lay saying, get away from me or I'll kick your ass. That's a conditional statement. You could phrase that as, if you don't get away from me, then I'll kick your ass. That's not, I'm here to kill you, old man. That's not, today's the day you die, buddy. That's an expression of, get away from me or I will defend myself. I said, what are you going to do? That's Gerald Radford. That's the statement of every bully. That's the kid you knew in high school or you knew in middle school who would go up to somebody and start pushing them. Find the weaker kid and bully them. What are you going to do? What are you going to do? What are you going to do? Because that's what Gerald Radford did for months. Did for months to John Lay. That's Gerald Radford's words. And go back and listen to that. Go back and listen to about 5 minutes before that when he starts telling the entire history of their relationship. Because you know what you're going to see? He's not concussed. He's not crying. He's not confused. He's relating exactly what the history between the two of them was. He's not saying, I don't remember what he said at all. He said, get away from me or I'll kick your... Well, I don't know what he said. I don't know if he said, I'll kick your ass. He didn't say, I don't remember if he said, get away from me. He keeps that part. You may have heard in the first interview with Gerald Radford, it comes up, and then when we read in the transcript of the testimony from December 6th, it came up again. Gaslighting. That's the phrase Gerald Radford used to describe the mistreatment he was enduring from the victim. He was gaslighting him. And you may remember that I even called out, I said gaslighting. It's the 2022 Merriam-Webster word of the year. There it is. Manipulating, grossly misleading, or downright deceitful. The defense has stood up here and suggested that John Lay was gaslighting. He literally said he was setting up an alibi in some sort of grand plan. Detective Harrow, gaslighting you. He's being grossly misleading and downright deceitful. The state attorney's office, gaslighting you. I am cherry-picking the evidence. Well, there we go. I never did anything to him. I never insulted him. I talked to him and treated him with respect just like everybody else there. That's the words of Gerald Radford. That's his first words. Is that gaslighting? I swear to God, I never did a damn thing to the guy. And I don't know why he started on me. You don't know why he started on you? Is that gaslighting? No. I don't think I ever threatened him. 6 people. 6 people came here to talk about what Gerald Radford did. Is that gaslighting? Are they gaslighting you? Or is Gerald Radford gaslighting all of us? Who's gaslighting who? You know, as I was sitting there, I thought of these quotes. Words may lie, but actions will always tell the truth. A lie stands on one leg, and truth stands on two. And the reason that means is because you can knock a lie over. It's not some stable footing. That's what the state of Florida has done. I have done that because, as I have said over and over, this is the question. I killed him, but, it was self-defense. And if you don't think it was self-defense, I killed him. That's what's left. That's what's left. It's like simple math. Now, Mr. Futch got up here and made a variety of suggestions of things that I have said or that have happened in this trial that are meant to mislead you or cherry pick or confuse you or whatever the case may be. But I really want to make sure a few things are set straight. First, the state of Florida has never suggested and is not suggesting to you that Gerald Radford killed John Lay because John Lay asked him out for a beer. Because remember, that was back in the past. What I'm telling you is that John Lay asked Gerald Radford out for a beer. Mr. Radford didn't like it, and that's when fucking faggot started. That's why I bring that up. Because Gerald Radford and the defense want to tell you, this is all just the First Amendment. These are all just people having reasonable disagreements about politics and mask mandates and COVID and vaccines. It is not. It is not. Fucking faggot came about because Gerald Radford had a guy make a pass at him and he didn't like it. Which is a ludicrous thing to do to begin with, because I can't imagine how many people, but especially how many women in the world, must have a guy make a pass at them, and we would all look at them if they just ran around yelling at people some horrible invective. That's not what we expect. But they're right. Mr. Radford can say that all he wants, except you can't keep saying that about the guy that you want to break his jaw, punch him in the face, fucking kill him, and then actually kill him. The defense has tried to talk about how I pointed out the picnic bench because that's some sort of indication of there was this plan to kill. That is not what I'm saying. If I wanted to argue to you that Gerald Radford planned to kill John Lay on February 2nd and that there was some elaborate plan in place where he was laying in wait, we would have charged him with first-degree murder. We didn't charge him with first-degree murder. We don't think this is a premeditated killing. We think this is two guys who had a fist fight, and Gerald Radford exceeded the scope of the law, pulled a gun, and shot a guy illegally, not in self-defense. That's why it's second-degree murder. That's why I talk about hatred, ill will, spite, or evil intent, and not premeditation. I only talk about the park bench because it shows Gerald Radford is behaving in conformity with the behavior you've heard about him at every place. He knows John Lay is coming. He knows where he's going to be, and he wants to just have his usual bullshit argument with him. He wants to bully him. That's what he was planning. He wasn't planning a murder when he's waiting by the park bench. I suggest to you he was never planning a murder at all, because that would be premeditation. He killed him out of hate, in the moment. The defense tried to tell you that this is a hate crime. Well, ladies and gentlemen, again, I can't say this enough. Words matter. This is literally the law for the crime being enhanced or the aggravation by the intentional selection. Where's the word hate? Where's hate crime? It's not a hate crime. Do you know what the hate crime is? There! It's second-degree murder. That's the hate. Here, you just gotta select them. And you can figure it out. A person could just decide, I want to kill a certain group of people because I just want to send a message. I don't necessarily hate them, although I think if you kill someone, you probably hate them. But that's not the standard. It's not a hate crime. It's just the intentional selection. The hate is here in second-degree murder, and the hate is there in Gerald Radford's heart. The defense also tried to suggest to you that I have tried to diminish the fact that there is no surveillance video. That I said, there's no surveillance video, but we don't know. I'm just stating logic. We don't know what the video contains. No one can say for sure. But I'm not trying to tell you to ignore that. But I'm also telling you to follow the instruction. You're going to get an instruction called Weighing the Evidence 3.9. And I talked about this during jury selection because, of course, I had the information and you didn't know yet. But I talked with you about, what if there's no fingerprint? What if there's no DNA? What if there's no surveillance video? Well, there's no fingerprints. The DNA didn't help a whole lot. And there's no video, right? But that's not the standard. Whether the state has met the burden of proof does not depend upon the number of witnesses. I didn't have only one witness. I had a whole bunch. But in fairness, you could say, other than Mr. Radford, I didn't have any witnesses to what happened in the dog park. Because the other guy is dead. It's not dependent upon the number of witnesses this is called or the number of exhibits it has offered, but instead upon the nature and the quality of the evidence presented. That's what you judge me on. Mr. Futch has made a pretty bold claim. And he didn't mince words about it. He said it to you over and over again. He told you that not only did Gerald Radford act in self-defense, John Lay was a criminal mastermind trying to set up an alibi. Right? It's not just two guys that fight. This was all planned by John Lay. He was setting up an alibi. I submit to you, ladies and gentlemen, that is preposterous. Just stop and think. John Lay already had an alibi if he wanted to hurt Gerald Radford. Was Gerald Radford already calling him a fucking faggot? Was he already doing it multiple times? Was he already doing it in front of other people? Was Gerald Radford already blocking the path of Mr. Lay? Were the people who saw it already concerned for Mr. Lay's safety? Were they already telling him to call the police and to get somebody involved? If it had been the other way, and John Lay was sitting here and Gerald Radford was dead, he already had all that. Why does he need to set up an alibi? a single selfie video. It's ridiculous. It is asking you to ignore what your eyes are seeing and your ears are hearing. Just consider the dichotomy, because this entire trial is a dichotomy. Fear or hate. Justified or unjustified. But even the two men are the dichotomy. Gerald Radford is a bigot. Everything he did was bigoted and hateful and aggressive and threatening. And person after person came up here and told you that John Lay was laid back, peaceful, non-confrontational. I think one woman described him as a scholar, not a fighter or a warrior. And they want you to ignore that. That's gaslighting. They're telling you to ignore what your eyes see and your ears hear. That's not cherry picking. I'm literally telling you, look at the evidence. This is the standard. I made no secret about it. I didn't try to hide it. I did it. Remember? The Kentucky Wildcats. Whenever the phrase reasonable doubt is used, you must consider the following. We define a reasonable doubt in the negative. It is not a mere possible, speculative, imaginary, or forced doubt. Mr. Futch stood up here and started talking about how Dr. Deaver said all of these things are possible. And that's true. Medical science can only tell us so much from an autopsy. But when I stood over Mr. Chambers, who was on his knees right here, and I drew the gun and it just instinctively went to the right spot on his body to shoot him, certainly it's possible. But is that reasonable? Is that more reasonable than the other things you had to watch me do with Mr. Chambers, where he had to like stand on the step ladder, so I was further down on the body, pretending to be Mr. Lay, further down on the body of Mr. Radford, and Mr. Radford would draw the gun, and the gun has to go somewhere all the way across the head of Mr. Lay and come over to the left side of Mr. Radford's body, and then turn the gun back, and then finally find the magic angle. There's a logical thing that says Occam's razor. Given two options, the simpler one is likely to be true. So, yeah, judge me, ladies and gentlemen, because that's the burden. But judge me on this burden. What is reasonable? Is it reasonable that John Lay got a bunch of scuff marks and gouges to his knees because he's on the floor struggling for his life, fighting over a gun? And that's why he gets shot downward from a man standing behind him, who in that instance is absolutely positively not acting in self-defense? Or is it some complex thing where Gerald Radford was laying on his right hip, doesn't get any dirt on his pants, doesn't get any marks on his pants, he somehow rolls over, he gets the gun free, he doesn't do the instinctual thing, which is what he demonstrates in the first instance, which is he just fires from the hip into the left side of John Lay. No, instead, now Mr. Lay wrestles over the gun. Well, Mr. Radford is on the ground. So if I put my back to this wall and pretend that that's the ground, when I draw the gun, the guy who's on top of me, the easiest way to take the gun away from me is to push the gun this way. He has the advantage. He's 50 pounds heavier, and he's leaning on me. It's the strength of my one arm against the sum total of his body weight. But he doesn't do that. No. Gerald Radford, who is somehow too weak to resist Mr. Lay, manages to somehow get the gun all the way over, like this. And then in the most awkward position possible, do this. While still having Mr. Lay's finger in the trigger guard, and disengages the safety because Mr. Lay is somehow furiously pulling the trigger. It's just not firing because the safety's engaged. Because John Lay has a gun pointed at him, but he's pulling the trigger. Let me pull the trigger now while the gun's pointed at me. Is it possible? I guess. I think it borders on Little Green Men from Mars, but you may feel differently. but it's definitely not reasonable. You have to force yourself to believe it. You have to find a way to imagine that. You have to speculate. That is not a reasonable doubt. The defense showed you this instruction. It's called weighing the evidence. It's a 3.9. And I always like the fact that right at the beginning, it does exactly what I asked you to do before. Use your common sense. Look, I got a chance to read all your verdict forms. I even knew which of you had friends or family members who were lawyers. None of you are lawyers. Jurors don't have to be lawyers. We ask average people who are almost certainly almost not lawyers. We don't want to pick lawyers, I'll tell you that. Right? We just want people with common sense. I just want you to use your common sense. I want you to stop for a minute and think about this statement. Remember this moment? Mr. Futch held up these two pictures and told you that this guy got the worst of it. That guy's dead. That man gets to keep living. He gets to keep breathing. He gets to dream. He gets to love. He gets to hope. This guy gets none of that. This guy got the worst of it? I have gone to great pains to look for all the other things that you can turn to for indications of what happened. And that is why I have focused on things like dirt on the jeans, dirt on the face, dirt on the speaker, dirt on the gun. It's why I have focused on things like the number of bullets in the gun. This is State's Exhibit 4E and 4F. That's the way Gerald Radford left the gun on the table. That's before it's been picked up, before it's been moved. It's sitting next to the beanie hat. You can still see the kind of red color of the beanie in the corner. That gun has no bullet in it, and it's got 6 rounds in the magazine. And so, since Mr. Futch read the transcript to you, and I need to be clear, ladies and gentlemen, because we have this problem all the time, you don't get the police report, you don't get the transcripts, you have to rely on the things you hear. We're not going to give you those things on paper. This was said. This is from Mr. Radford. He's asked, you wait for law enforcement to arrive? He says, I did. I walked from where the scuffle took place, walked over to the table, and as I was walking over, there was 2 rounds jammed in the slide. 2 rounds. The stovepipe round that didn't eject, and the follow-up round that was pointing inwards with the primer out, and that couldn't load into the chamber because of the stovepipe round. So it just had it blocking the slide. So it took me a few tries to get it out. And I know that the round fell out because it hit me on the foot. It wasn't an empty shell. This hit me in the foot. It had bullet weight behind it. Okay, so stop and think about what Gerald Radford has said. Here's the gun, and here's the magazine. Okay? If there was 6 in the mag and 1 in the chamber, the one in the chamber is the one that's stovepipe. And so one of them had to come out of the mag to go up into the chamber as part of the stovepipe. Because there's 2 in the slide. And it has to be a live round because he says it's a live round that falls out of the slide, ejects out of the gun when he's clearing the stovepipe and falls on his foot. So there can only be 5 rounds left in the mag. Now, why does that matter? Mr. Futch stood over here and told her to tell you that the 911 call was a spontaneous moment of emotion by Mr. Radford. He said there was no time for reflection. And I submit to you that's just not possible. Gerald Radford had a fight with a man, and in a moment of really, really bad judgment, because he doesn't understand what the self-defense laws in Florida are, he shot and killed his opponent. And I submit to you that if he's having an emotional moment, it's because he's just killed a man. Okay? But now, he's got a gun in hand, it's loaded, and it's stovepiped. It takes 2 hands to unload the gun. It takes 2 hands to clear the stovepipe. So he's not on the phone yet, talking to the police. He can't be clearing the phone, he can't be on the phone and clearing the gun, right? He's clearing the stovepipe. The bullet's falling on his foot. He's got to stop, he's got to pick it up, and then he's got to put the bullet back in the mag for some reason. And I know Gerald Radford is going to say, I was trying to do the right thing, I was trying to render the weapon safe. Well, first off, the weapon was safe. Right? It wasn't firing. That's what a stovepipe is. It can't fire. And even if you did clear it, what's the need to put the bullet back in the magazine? The magazine's not in the gun, the bullet's not in the gun, it's no danger. Right? But he did. He had the time for that. He had the wherewithal and the focus to do that. Remember, that's one of the first things that's happening after the moment. And then if you listen to the testimony that was read into the record, Gerald Radford also picks up his speaker. Remember? Because there was that whole thing about whether or not there was sand on the speaker and whether or not he picked it up. So he's got to have time to pick up a speaker, unload a gun, clear a stovepipe, reload a mag. He still hasn't even started making the 911 call. But interestingly, Gerald Radford, a man who needs glasses to see up close, remember these things, his transitions? The ones covered in the sand from the park a year later? He doesn't go get those, because he talks about he's trying to dial the phone 999, right? No one looks at their phone like this. You put your phone here and dial it. He doesn't go get his glasses, right? Because he's focused on the gun. He's focused on the murder weapon. Because he is having to think about what to do. Because he has shot someone and killed someone. And he's going to have to find a way to explain it. And again, I'm telling you, I'm not saying he planned to kill him. I'm just saying he did kill him, and he did it out of hate. Okay? So he's reacting to a bad decision he made. Now Gerald Radford gets on the phone, and he has the wherewithal to say, well, I'll tell the police when they get here. He could have started vomiting all of the information, but he doesn't. Okay? And Gerald Radford told the police he went ape shit. Do you remember that moment? I literally spelled it into the record to make sure it wasn't misheard. That's what happened. He lost his cool. He got angry. Spite and hate and ill will and evil intent overtook him. So, you know what, ladies and gentlemen? Maybe this is the day. Maybe this is the day that John Lay threw the first punch. Maybe this is the day that he said, you know what, I've had enough of this bully and his bullshit. Okay? Maybe that's true. And that would certainly explain why a person who doesn't understand self-defense laws in the state of Florida and who made a really bad decision when he was angry would think to tell the police, go get the cameras, go get the cameras. Because it's going to show that Gerald Radford walked up to John Lay and was bullying him and berating him, and John Lay maybe threw the first punch. Okay. And Gerald Radford would have been perfectly, lawfully justified to fight back. But here's the thing. Gerald Radford says, the fight starts with this weapon. The bubble mug. Okay? And maybe you think, well, yeah, look, I mean, it's a weapon, and Mr. Radford got hit in the face, and, you know, there's obviously some injuries to his face, and he must have been hit with something pretty hard. I mean, Okay, great. It doesn't crack the glasses in any way, but hey, the world's a weird place. But here's the problem. That's the first punch. That's the first hit. Gerald Radford then says we're on the ground or whatever, but if you listen to the first interview, he says I get hit in the face and then I grab him. And then I fall. Not I'm knocked down, right? Because Gerald Radford is ready to have the fight. And now the fight has started. He didn't start the fight with the gay guy. He got his wish. Just like Albert Darlington sat here and told you he could see with his own eyes as a person there in the moment. He confronted Gerald Radford and said, what are you trying to do? Are you trying to get him to start the fight? And Gerald Radford just smiled. Because he knew that either he was just going to keep bullying Mr. Lane indefinitely, or someday Mr. Lane would throw a punch and then he could let him have it. But here's the thing. Even if John Lay threw the first punch, even if John Lay started the fight, every account from Gerald Radford says John Lay is hitting him with his hands. Maybe the first one is with this bottle, but every account says he's hitting him with his hands after the fact. He doesn't say he's beating me with this hard metal object. He says he's hitting me with his hand. It's a fist fight. And you don't get to shoot the guy in the fist fight if you don't reasonably believe that you're going to die or you're going to suffer great bodily harm. That's the standard. Gerald Radford was the guy with the gun. I suggest to you that Gerald Radford was the guy emboldened by the fact he had the gun because he knew he had the gun. He could be the bully. He could push and push and push and say, what are you going to do? What are you going to do? What are you going to do? Because he had the ultimate trump card. He had the power of life and death. And that's what happened. John Lay is dead, and Gerald Radford sits here. And you have to answer the question of what was in his mind, what was in his heart. And look, you are the jury. You can decide whatever in the world you want to decide. But if you're going to ignore what your eyes have seen and what your ears have heard over and over and over again, well, then you're being gaslit. Find the defendant guilty. John Lay is dead. This is not some political prosecution. This is not something that we simply wave away. It's not anything that I told you up front. Because, remember, like Babe Ruth, I stood here and I called the shot. We're going to say it's the First Amendment, it's no big deal. I hit first base, second base, third base, fourth base, home plate, home run. Hold the defendant accountable. Use your common sense. Find the defendant guilty. Thank you.
All right, for those of you reading along with me, I'm picking up on page 10 of 12 in your jury instructions where it says 3.13, submitting the case to the jury. So in just a few minutes, the bailiff will take you into the jury room, and the first thing you should do there is choose a foreperson who will preside over your deliberations like the chairperson would of a meeting. The foreperson should see to it your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's responsibility to sign and date the verdict form when all of you have agreed on a verdict and bring the verdict form back here into the courtroom. You will discuss this case with your fellow jurors to reach an agreement. Again, your verdict must be unanimous. Each of you must decide the case for yourself, but you should do so only after you've considered all the evidence, discussed it fully with other jurors, and listened to the views of your fellow jurors. Do not hesitate to change your opinion if the discussion persuades you to do so. However, you should not surrender your considered opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. Do not change your honest belief about the weight and effect of the evidence simply to come to a verdict. During deliberations, you must communicate about this case only with one another, only when all of you are present together in the jury room. If, for example, a juror goes to the restroom, the deliberation should stop until that juror returns. You're not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through any other means with anyone else, and do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of this case, and if you become aware of a violation of these instructions or any other instructions I've given you, please let me know by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, other electronic devices here in the courtroom. Our rules of procedure do not allow you to take those into the jury room, so leave them with the bailiffs. They'll be secured and guarded while you deliberate. If you do need to make a quick phone call or text to someone to let them know you're about to begin deliberations and so you will be incommunicado for a while, you're welcome to do that before your deliberations start. The bailiff will also explain to you how you advise us when you've reached a verdict or how to communicate with us if you have a question. If you do need to communicate with me, send a note through the bailiff signed by the foreperson. If you've already voted on one or more of the verdicts, do not disclose any actual vote in your note. If you do have a question, I must discuss it with all court personnel to determine first whether legally and procedurally we can even answer it, and secondly, if we can, how we will do so there will be an obvious delay in any response to you. You may continue your deliberations if you're able to do so while you wait for our answer. I will answer questions either in writing or orally here in the courtroom. Please, though, understand we cannot answer questions dealing with the testimony of the witnesses you've heard during this trial. You must rely on your own recollection of the answers the witnesses gave to the questions that were asked of them. We cannot give you an answer to any question that was not asked, nor can we explain an answer that was given by a witness. During the trial, certain items were received into evidence as exhibits. All of those exhibits will be sent into the jury room with you when you begin to deliberate, and you're free to examine any of them in the jury room. However, you may see and consider only items or documents that were actually received in evidence. You may not see documents such as police reports or depositions that might have been discussed during this trial if they were not placed in evidence. As to the instructions on the law, you obviously have available to you this exact set of written instructions I've just read. There are no time limitations for jury deliberations. This is completely up to you as a jury. You may continue to deliberate as long as you wish. If you choose to deliberate past the dinner hour and would like us to order dinner for you, please let us know. Additionally, if at any time you would like to suspend deliberations and return tomorrow to continue, please let us know that as well. In closing, let me remind you it's important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For over 2 centuries, we've lived by the Constitution and the law. No juror has a right to violate these rules we've agreed to share. So with that, I'm going to give you, you'll have with you, as I said, the court's copy of the jury instructions. It's in yellow paper to distinguish it from yours. The verdict form is also on a yellow piece of paper to distinguish it from your juror copy. The exhibits, as I said, will all go back into the jury room with you. It'll take us just a few minutes to get those together. I think you also have a list of the exhibits as well. Thank you that Angela has prepared for you that numbers them and tells you what they are, so you don't have to open things unnecessarily if you don't need to. So with the exception of Shane Kelly and Angela Simpkins, you are our alternate jurors. In Florida, 6 jurors, no more and no less, are required to deliberate on this type of case. We're required by law to have alternate jurors in case an emergency had happened and we didn't have 6 people to deliberate. We would have to have started this process all over again. So you two stay with me for just a second, and I'll excuse the rest of you to begin deliberations.
All rise.
Testimonial
All right, that was quick jury instructions, faster than I thought. But the state came back and they said, if you do anything, I'll go back and listen to 13 minutes and 10 seconds into the recorded audio of the first interview. They were walking toward each other. He says, "Get away from me," or "I," and then Radford stutters. They were walking toward each other. It's not Lay ambushing him. "Get away or I'll kick your ass," meaning that's what Lay said. "Get away or I'll kick your ass." Not, "I'm going to kill you, old man." And he's like, that's the kid in middle school that you knew was a bully. Gaslighting was the 2022 Merriam-Webster's word of the year. Who's gaslighting who? We don't think it was premeditated. He said that a couple of times. It was two guys having a fight and Radford pulled a gun. Radford was a bigot. Lay was a scholar. Then he talks about the 2 rounds that were jammed. I didn't quite get this one. There were 6 in the magazine, 1 in the chamber. That there can only be 5 rounds left in the magazine because 1 was shot, right? One bullet was shot. It takes 2 hands to clear a gun, so he can't be on the phone and clearing the gun at the same time. I guess he was trying to get that he was kind of nonchalant about it. He wasn't shaken up. I think that's where he was going with that. He was hitting, and then he goes, switches gears and says he was hitting. It was a fist fight. He was getting, according to Radford, he was getting, what do you call it? Hammer fisted. Not with a metal mug. He wasn't getting hit with a metal mug. He says it's a fist fight. You don't get to use a gun. And then the jury instructions came up from the judge, and it was only 6 jurors. Only six jurors. All right, take the poll, you guys. We got a poll going. I can get rid of that. 31 votes. How long will the jury take to deliberate? We have 0 to 1 hour, 1 to 3 hours, 3 to 5 hours. So I'll give you another minute or two here. Look at Super Bowl while you guys vote. She's so cute. Super Bowl. She's so cute. She's being very cute. Hammer fisted. Yes, the old hammer fist. I had to look it up. Capri Law. And it's like a what do you call it? MMA, I guess. I don't watch that stuff, but oh, come on. Sorry guys, I'm really sorry that I'm trying to sort my so sorry about that. Kitty, yes. It's like you're basically, I think you're hitting with this part of the instead of a punch, you're hitting like that. Your mom was hammer fisted. Therapist. Runs with scissors. Hey, how are you? Haven't seen you in a while. Fala. Kitty. Capri Law. Kitty. Widespread panic. Kitty. Ken Rosenberg's. Super Bowl seems to be having a harder time paying attention since she got that bad. That is true. She is not paying attention as much as she used to. She's slacking on her duties. Shirley Roth, yes. Hitting with the meaty part of your hand. Yes, so that would be your meaty part. You're doing one of these. You know, I'm sorry, but all I can see is I'm not going to even do this, but not going to do it. Runs with scissors. So good to be here with you all. Thank you. Appreciate it. Sinbad, state's rebuttal made me more convinced there is too much reasonable doubt. Facts don't care about feelings. Fact, there was no proof as to what happened that day. I'm sticking to not guilty. All right, I'm going to end said poll. 13 minutes, 34 votes. Poll is closing. There it is. All right, so 34 votes. How long will it take the jury to deliberate? Out of 34 votes, we got 50% of you said 1 to 3 hours. 41% of you said 3 to 4 hours, 8% said hung, and 0% said 0 to 1 hour. All right. You guys ready for the answer? Hey, Abel, how you doing? Thank you for dropping in. Appreciate it. All right. The jury took, drum roll, please. Oh, sorry, Super Ball. I just woke her up. Took about 2.5 hours for the jury to deliberate. 2.5 hours. So, what do you think the verdict was if it only took them 2.5 hours? What do you guys think? Oh, Crowd Junkies United. Moo was bashful last night. She needs to watch more Super Bowl. I know. Cute. She'll come around. She'll come around. Widespread panic. I don't think there's strong evidence for the hammer fisting. Someone remind me, were the injuries? No, there were no injuries on Lay's hands except on his pinky, I think. Just on his pinky, and that was it. So, all right. So now that you know that it took 2.5 hours, what do you guys think? You're going not guilty, Capri Law, Sinbad, not guilty, Grass is Green Enough, not guilty, Lily Wayne, not guilty, Shirley Roth, not guilty, OnlyFan hung. You, sir, out. Baca, quick verdict, guilty. Kathy Smith, guilty. Alice, not guilty. So the majority of you are saying not guilty. Abel says to Sinbad, hey, wifey. Callie Graham says guilty. Nanar says guilty. Trial Junkies United, objection. It's about a dog park. Super Bowl isn't interesting. Nice. Let's see. All right. Plea deal. Stop with the plea deal. Plea deal. You, sir, out. You can take your plea deal and get out. Care Bear, not guilty. Lots of not guilties. All right. No way, Drunkie. Wait. You got an email from Beth Silverman? No way. Oh, you do have to tell. Brad, only mark was on a knuckle, nothing on the side. Yep, it was his pinky, I think, if I remember correctly. Let me pull that up. Pretty sure it was like his pinky, left pinky. Let me see. Pinky. Right pinky knuckle is the only area with a little scrape. So his right pinky. No damage to his forearms or his left hand. Dirt on his knees. So he did have a lot of dirt on his knees. So that would make you think he was on his knees doing, pounding. Because how else would he have gotten dirt on his knees? So he may very well have been on top of. I could see that as a scenario. I could see they get in each other's face. They're like, F you, you're, and then, they grab each other. And because Lay is bigger, he does somehow get Radford down, but I don't think he's doing the hammer fisting. I don't think he's doing that. And then I'm still having trouble with the gun because the only way you're going to get that angle, right? Because don't forget the angle of the gun, the bolt, it came in here. So it came in like here, right? And it exited like down here. Like it literally was like that. So you'd have to be shooting, which is possible. I mean, he could have been like, yo, could have done that, which I don't see him as like, as gangsta. He's not going to do that. So I can see him being on like if this is this face, and they're struggling. I can see that. So, yeah, he is guilty of being a jerk, though. Yes. All right, let's get to. He's doing it on purpose. I'm not sure what that's for, but okay. Sinbad, you broke your pinky twice, hammer fisted a board once in a volleyball spike. Wow. I can see, well, the volley, yeah. You did it, so you know what the hammer fist is. Care Bear, he could have hit the picnic table. Mad about what happened. No, this was Lay. Lay had the pinky. It was Lay. The deceased. It was the deceased. Dwayne. Dwayne. You get a finger wag for that. All right. Dwayne gets a finger wag for that comment. All right, let's go back to the verdict. We got the verdict. The verdict is in after about 2.5 hours. After about 2.5 hours of deliberating. Verdict comes in. Man, I hate the way that audio comes back in. All right. We have a verdict. All right, here we go.
All right, be seated. My understanding is you have reached a verdict. Is that right?
Yes.
If you would hand the verdict form to the bailiff for me. And the verdict form is in order. If you publish the verdict and poll the jury, please.
Yes, ma'am. State of Florida versus Gerald Declan Radford. Case number 24-CF-003630A. Trial Division 3 verdict form. We, the jury, find as follows as to count 1, second-degree murder. The defendant is not guilty. So say we all, dated the 6th day of February 2025. Juror number 1, foreperson of the jury. Juror number 1, is this your true and correct verdict?
It is.
Juror number 2, is this your true and correct verdict?
Yes, it is.
Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict?
Yes.
Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Thank you. Ladies and gentlemen, I just want to spend one more moment telling you again how very much I and we appreciate your service here this week. As I told you earlier this week, we can't do what we do in this courtroom or any courtroom in this country without people like you who have responded and made this great sacrifice. The right to a trial by jury is fundamental to our system of justice. So I'm very sincere when I tell you my constant admonitions about not talking about the case are obviously lifted. You can do as much or as little of that as you would like to. You are never required to talk about your jury deliberations or your jury service absent a court order. But if you do choose to talk about jury service with others, I hope it has a somewhat positive spin so that if they get a jury service summons, they too will come down to the courthouse, as you all have done this week. So that much being said, if you have any questions or would like to speak to any of the lawyers afterwards, you can let the bailiffs know. They'll let you know how you can effectuate that. I think you all have my contact information. If you have any feedback or input that you'd like to give me, I always welcome that as well. So without further ado, I want to thank you again for your time and attention and sacrifice this week. I hope you have a great rest of your week and a great weekend, and you are officially released from your jury service. Thank you.
All rise.
Be seated. Jury having found you not guilty, I will adjudge you to be not guilty, Mr. Radford. This is the only thing holding him at this time. Is that correct?
Yes, ma'am.
All right. Thank you very much.
Judge, may I release the evidence back to the state?
Yes, I'll sign an order releasing the evidence back to the state as well.
Court is adjourned. Ladies and gentlemen, answer the court, please.
All right, don't go anywhere because I have 2 things for us to watch after press conferences. So don't go anywhere. We're not done with this trial just yet. Did you guys all answer the verdict, or do you agree with the verdict? 30 votes. I'll give it a few more minutes. All right, so let's go to post-verdict news number 1. This is post-verdict news clip. Watch your ears, so just be aware of if you have headphones on, watch your ears.
Tonight, the verdict is in. Tonight, the verdict is in. The man accused of a hate crime killing at a Hillsborough County dog park is found not guilty of second-degree murder. Gerald Radford shot and killed Walt Lay last year. He claimed Lay attacked him in the shooting with self-defense. Prosecutors say Radford targeted Lay for months with vile, homophobic language. News Channelist Jeff Patterson joining us live at the courthouse tonight. And Jeff, Radford really seemed to have no reaction when the verdict was read. At least that's what I saw there. What's been the reaction since court was dismissed?
Good evening, Keith. Well, I guess shock among a lot of people. Gerald Radford will be able to go home tonight for the first time in months as a free man. A jury found him innocent, not guilty, on charges of second-degree murder, and they did not accuse him or find him guilty on any lesser charge. So tonight, Radford will go home a free man. The verdict was read in court just a short time ago.
We, the jury, find as follows as to count 1, second-degree murder. The defendant is not guilty.
Radford claimed self-defense all along, even saying in the initial 911 call after the shooting that he had been forced to shoot a man. Prosecutors say Radford harassed his victim for months and even threatened to kill him. But in the end, the jury found this was a case of self-defense, and Radford's attorneys say the jury simply followed the law.
You know, Mr. Radford maintained his innocence the entire time, that he was attacked by Mr. Lay, and I do echo and stress what I said in closings, that it was incredibly tragic what happened on February 2nd, but Mr. Radford was innocent. He wasn't guilty, and we're so thankful that the jury got it right.
Radford's attorneys did tell me after the verdict was read that he was within his rights under Florida law to carry a weapon, and that's why they believe the jury found him not guilty on all charges. Live in Tampa, Jeff Patterson, 8 on your side.
All right, so that's that. Now we're going to hear from, there's some more reaction coming up, and then I'll end the poll. Do you agree with the verdict? For those that have not voted yet, please vote. And watch your ears. Watch your heads up with ears.
We saw tears of joy today in the courtroom from this. We saw tears of joy today in the courtroom from this man, Gerald Radford, after a jury in Hillsborough County found him not guilty of murder. This was the Tampa dog park case. Remember, Radford was accused of killing a guy named John Walter Lay out of hatred over Lay being gay. Now, Radford always maintained that he shot Lay in self-defense at that dog park, and today the jury sided with him. Fox 13's Evan Moon is outside the Hillsborough County Courthouse with reaction from the victim's family.
It was just over a year ago when John Walter Lay was killed, and tonight his shooter walks out of jail a free man after a not guilty verdict. I spoke with his attorney after the verdict, as well as the victim's sister, who said she was shocked.
Second-degree murder. The defendant is not guilty.
Gerald Radford will walk away a free man tonight after a jury found him not guilty in the death of John Walter Lay.
Mr. Radford maintained his innocence the entire time, that he was attacked by Mr. Lay.
Last February, Radford shot and killed Lay after a fight broke out at the West Dog Park in Tampa. We spoke with the victim's sister after the verdict.
I think they just didn't really look at the facts. I think they wanted to go home. It'd been 5 days and they were done.
She tells us she is in shock at the outcome of the trial and is still mourning her brother's death.
How do you lose a loved one and move forward? I mean, you have to. This jury has just set a precedent for other people to shoot someone if they get punched.
Prosecutors said Radford and Lay had been friends that knew each other through regular dog park visits, but that changed when Lay asked him out, and Radford began calling him homophobic slurs and making derogatory remarks about Lay's sexual orientation over the course of a few months.
Gerald Radford has all the hallmarks of the bully in this indication, in this situation.
But the defense said Lay was fed up, attacked Radford, and Radford shot back.
He did, he being Mr. Radford, everything we as a society would ask somebody to do if they ever find themselves in the difficult, traumatic, and arguably one of the most horrific situations you could find yourself in. To take another human life to save your life.
Still, John Walter Lay's sister says Radford should be in jail.
There was so much evidence showing that he really did hate my brother, and it's like they just didn't hear any of that. And the angle of the shot in itself showed that it was a execution style shooting, and how could that be dismissed? So I was very shocked.
Hillsborough State Attorney Susie Lopez's office released a statement saying that she disagrees with the jury, but she respects the outcome. The statement says, quote, "The fact that this victim was forced to endure hatred and prejudice from the defendant based on his sexual orientation shows that our society still has progress to make towards equality." At the courthouse, Evan Meehn, Fox 13 News.
All right, so that let me end the poll, and we're going to portal you guys over. Shanna Gardner had a pretrial hearing today, this morning, so we're going to cover that. So stick around. We're going to portal you guys over for that. But I'm going to end the poll. Do you agree with the verdict? Poll is ending, and 60% of you said no. So, out of 43 votes, 60% said no, 39% said yes. I think they didn't do this lesser included because I think if he's not guilty, he's not guilty, right? I think that's, excuse me. I think if he's not guilty, that's why they didn't go on to the lesser included. I think not guilty just kind of wiped everything off the board, if you will. Shanna Gardner is accused of deleting her husband, who worked for Microsoft, with her other husband. It was her ex-husband, and it's taking place, I think, in Jacksonville. So, all right. That is going to conclude our coverage of Florida versus Radford. Appreciate you guys being with us as always. Let me just see. Shanna Gardner. Okay, yeah, we're going to start at 3:45. So I'm going to take just a quick little break, and then we'll catch you guys over there. Thank you for joining us. Thank you, Aaron, for all that you do on the back end. Thank you to our fantastic mod squad. You guys are the best. Thank you, chat, for being with us. We're going to cover Shanna Gardner. He was shot. Her ex-husband was shot. I think their 2-year-old daughter, 3-year-old daughter was in the back seat. I think it was a Microsoft. He worked for Microsoft, I believe. So yeah, join us for that. That's going to be an interesting one. So it's pre-trial. So thank you guys for watching. Please join us over for the Shanna Gardner. Appreciate you guys watching the dog park murder trial with us while we're waiting for Monica Cementilli to kick back in, which she will kick back in on Tuesday. And then Lori Daybell starts her, that's the next big one on our radar. We are absolutely going to cover that. And Joe Schmo is going to be covering it. He's going to be in the courtroom. So we are going to have some fun things for you guys lined up. So appreciate you joining us. And with that, I will say goodbye for this stream. Super Ball sends her wishes. She says goodbye to you all. Thank you for watching. And let's all hop over to Shanna Gardner. See you in a bit. Bye. Bye.